Good morning, everyone.
Good morning.
Can everyone hear me?
Morning.
Good morning. All right, we are continuing the matter of Roberts, Brangman, and Smith-Williams. Today, the appearances are as before, and we are again before my Lord President, Sir Christopher Clark, and Mr. Justices Anthony Smelly and Jeffrey Bell.
Now, I have a preliminary matter about timing. We are going to adjourn at 11:50 Bermuda time. Unfortunately, Mr. Coelho has to attend a family funeral, and we must endeavour to accommodate that. So we will adjourn at 11:50, and I hope that he will tell me when we've got to 11:50, and we will resume at 12:50. Sorry, would you forgive me a moment? Sorry. So that's that. Now, Mr. Mahoney, a number of questions have arisen in my mind overnight, and I hope you won't mind if I ask them now, and hope that won't put you out of your stride.
No, sir, I'm here to assist the court.
Thank you. Can we first look at the judgment in Trott and look at paragraph 51, which is in the joint bundle of authorities at page 162. Have you got that?
Yes, sir.
In paragraph 51, the Chief Justice says, further, even in the absence of a formal challenge by either party, the trial judge has a residual discretion to exclude from the jury a juror selected by the initial ballot. And there's a citation from some observations of Lord Justice Lawton. And if you look at footnote 9, it refers to Blackstone's Criminal Practice 2019. My basic question is that correct? The reason for my question is that it may be that there is no Crown standby if either a juror is successfully challenged for cause, or if he or she is excused under the Jurors Act, or if the trial judge exercises a residual discretion. Do you see the point that I'm on about?
I'm just trying to reread the provision, sir.
Yes, of course. And I don't know whether what the learned judge is referring to there is in fact the jurisdiction to excuse under the Jurors Act, but he doesn't say so in terms.
Could I come back to that, sir?
Yes.
Actually, it was my colleague in the Attorney General's chambers actually argued the case before the learned justice.
Yes.
To the extent that it was argued. So could I return to that, sir?
Yes, and we might need to look at Blackstone.
Yes, sir.
So that's question number one. Question number two is I asked, where was the provision that the Crown could stand by up to 36 jurors. And you told me that it was in section 13 of the Jurors Act.
I think that was Mr. Pettingill or Mr. Lynch. That
Oh,
was
okay, Mr. Pettingill. Well, one of you did. I don't mind who. Section 13 deals with the selection and notification of jurors and provides for the registrar to select the panel of jurors. And on the day appointed, the registrar is, by means of a random number table or such other method as the Chief Justice may direct, select at random from among persons on that day included in the approved list, 36 names to comprise the panel of jurors and 36 names to comprise standby jurors. So what that is saying is that in working out the panel for any given session, the registrar is to select 36 potential full jurors and 36 alternate jurors. That's something different from saying the Crown has a right to stand by 36. I mean, it may be that if there are only 36 on the panel for jurors other than standby jurors, the maximum you're going to be able to stand by is 36. But it's not actually a provision that in section 5192 that you can stand by up to 36.
I agree with your interpretation, sir, because my understanding of the criminal code section prior to its amendment is that the Crown had unlimited standby. Whether it's 10 people are there, 15, 42, 72. So I'm not sure exactly where the Learned Chief Justice got that figure from.
I can assist.
Yes.
I think it is in the old section 5192 that my understanding is that the Crown had unlimited standby up to the number of 36. If you look at the old section 5192. I'm just trying to find it.
Yes.
And I've also found, because I prepared the submissions in relation to the constitutional application for Trott, I found the excerpt from Blackstone's 2019 D13.3637.
Well, I've got 5192. And 5192 reads, the Crown may apply that a person drawn to serve as a juror shall stand by until such time as his name is called a second time, and in such case the court shall order the juror concerned to stand by, and shall order the proper officer of the Supreme Court to draw from and call upon the remaining names of the jurors in the panel. There's nothing there about 36.
I totally agree with you, my Lord President.
Right.
I don't know how there must be an error in respect of that 36 summary.
Yes.
Can you answer that, please?
Sorry? What the Chief Justice said at paragraph 17 of Trott was the Crown is not allowed to exercise any peremptory challenges. However, the Crown is allowed to stand by up to 36 potential jurors under section 5192.
And that's not actually right. It's an unlimited number of standbys that the
Yes.
Crown can stand by under section 5192.
Yeah. And it may be that since there will be 36 as putative jurors, you're not in practice going to be able to stand down more than 36, but it's not actually what section 519 says.
The beginning of paragraph 18, he seems to have put it as an accident of history.
My lord, may I? So in answering the question about where 36 came from in looking at it, I mean, that does, the only mention of the number 36 is under the Jurors Act. And I think that if there's any confusion that's happening, it's on the basis that 5192 effectively makes it unlimited, because some panels have more, and Trott is a good example of this. If you look at earlier, Trott had 44 people on the panel that day. And I'm not really sure as to, there are 36 and then there are the alternates, but many a time, I mean, a jury the other day, happened to be in the Trott case as well, I think had 55 members on the panel that were actually in courtroom, and one would assume that some of those are the 36 and then some of partially the alternates that are selected. So it's a case of statutorily, under the section, 36 people are picked as the primary jurors, if you want to call it that, and then others are added in as the alternates, and they all get lumped into one pool. And effectively then the challenge is open-ended. So it could be that all 50 get challenged. It's not limited to 36. It allows for 36. I think what the Learned Chief Justice was doing was tying it in with that provision that technically there are 36 initial jurors, and then there are these alternates. But what happens in practice is, as I say, you can have 44, you can have 55. That number varies, but there tends to be, in my understanding, certainly a minimum of 36 that are there.
I think he seeks to explain how he arrived at the number at paragraph 18 over the page.
Yes, my lord. A historical accident, I think it is. Yes.
Yeah.
Yeah.
But I'm sorry, this is very confusing, because the statute provides for the registrar to select 36 names to comprise the panel for that session and 36 names to comprise standby jurors.
Yes.
What I think you're saying is that what happens in practice is that the registrar, well, what does the registrar do?
My understanding, my lord, is that the registrar prepares a list of a minimum of 36 jurors, and then in any given session, there could be more than that, and those people are then notified by the officer. But it is never a fixed number. I'm sure Mr. Mahoney may well agree that tends to appear. It tends to be a varied number in excess of 36. So she sends out the notice, but we never see 72 with respect, if that's the kind of question, where there's a backup room. How it works now is 12 jurors get selected, and then there's the alternates.
Okay, so the registrar selects a panel, putative panel, which may be more than 36.
Yes, my lord.
And you go through however many it is, first selecting the jurors proper, and then you embark upon selecting the alternates.
Yes, my lord.
Right.
If you run out, sorry, if you run out, the rule is then perhaps you go to the rest of the 36 names that are on a list somewhere, or you go to the street, which fortunately
playing the tails, yes. Yeah. Is there a provision about how many alternates there have to be?
Up to 3, I think.
Yeah,
up to 3.
Up to 3.
It's in the code, actually.
And that's at the discretion of the judge, is it?
Yes, usually the judge discuss with counsel and we agree. If it's a single accused and the case is likely to go for 2 or so weeks, we may agree on 1 alternate. If it is a more complex matter, we may agree to 2 or 3 alternates.
Okay. Right. So I think we're agreed that the right to stand by is in fact unlimited.
Yes, my
Yes,
lord.
sir.
Right. Thank you. Next item on the program. I wonder, Mr. Mahoney, if we could look at your submissions and at page 71 in the consolidated submissions bundle. It's paragraph 7 of your submissions on the application for extension of time to appeal.
That's the matter of Vestal, sir.
Well, yes, it's got Vestal.
Yes, sir.
What I'm on about is this. One question we may have to determine is what is the test for cases which are exceptions to the finality rule. And there appear to me at the moment to be 3 different candidates. If you look at Vestal, you say at paragraph 7, in Vestal, Lord Justice Pitchford, in examining the change of law cases and the principle of finality, stated at 15, Lord Justice Hughes's statement was approved by Sir Eager George in Cottrell. Now, Lord Justice Hughes's statement, as appears in some earlier paragraphs of Vestal, was that the practice was well established that where the conviction was entirely proper under the law as it stood, leave would only be granted out of time where substantial injustice would otherwise be done. And that's picked up in the citation of Sir Igor Judge. In short, the principle is that the defendant seeking leave to appeal out of time is generally expected to point to something more than the mere fact that the criminal law has changed or been corrected or developed. If the appeal is effectively changed based on a change of law and nothing else, but the conviction was properly returned at the time after a fair trial, it is unlikely that a substantial injustice occurred. So the English cases, and there are others, including Ruddock and Joji, seem to adopt a test of whether a substantial injustice has occurred. Sorry, this question goes on a bit. But if you then look at the Irish case, which is, if you turn the page of your submissions, it's A against the governor of Arbor Hill Prison. If you go to the bottom of page 72 of the consolidated submissions bundle, about 10 lines up from the bottom, the Chief Justice in Ireland said, in a criminal prosecution where the state relies in good faith on a statute in force at the time, and the accused does not seek to impugn the bringing or conduct of the prosecution on any ground which may in law be open to him or her, including the constitutionality of the statute, before the case reaches finality on appeal or otherwise, then the final decision in the case must be deemed to be and to remain lawful, notwithstanding any subsequent ruling that the statute or a provision is unconstitutional. That is the general principle. And he then says, I do not exclude some extreme feature of an individual case, which might require, for wholly exceptional reasons, related to some fundamental unfairness amounting to a denial of justice, and the words that haven't been included, that the verdict should not be allowed to stand. So if one's looking at the Irish case, the exception to the finality rule would appear to be described as a wholly exceptional reason related to some fundamental unfairness amounting to a denial of justice, which is not quite the same as a test simply of substantial injustice. And then, this is coming to the end of my questions now, if you go back to page 70 of the consolidated submissions bundle, paragraph 6 of your submissions says this: the respondent further submits that the general principle, therefore, subject to the limited exceptional circumstances, is that an appellate court has no authority to review its own decision pronounced after a hearing inter partes, where the decision has passed into a judgment which is formally drawn up. The principle is one that is strictly enforced and is deviated from in limited exceptional circumstances only. The applicant must not only place himself in one of the limited exceptional circumstances, but the injustice which would be meted out to him if his appeal is not reopened must be so substantial as to far outweigh the public interest in the finality of litigation. Now, although you don't refer to it at paragraph 6, that in fact comes from paragraph 60 of the judgment in Grant. So where one gets to is that the authorities have postulated 3 different cases: substantial injustice, fundamental unfairness amounting to denial of justice, injustice so fundamental that it far outweighs the public interest in the finality of litigation. Now, what I'm interested in is whether you embrace any, and if so, which of those 3, and whether the position is such that the test is satisfied if you adopt any of those 3, or only if you adopt one of them. That's rather a long question. You may want to deal with it a little later. But we'll have to decide, you know, what is the test?
Yes, sir.
And if we decide the test, what is the answer to it?
Well, could I attempt to answer the latter first?
Yes.
It's my submission that irrespective of what the test is or what the court decides the test is, these cases meet that test.
Right.
You say they meet it?
They do not.
Oh, I see.
Okay. Well, that'll do for the moment. But if you want to make further submissions as to which of those tests we should select, please do so.
Forgive me,
yes, I'm so sorry, Mr.
Forgive me, I'm so sorry. I'm afraid I missed Mr. Honey's position on that, which is quite important, obviously.
He says, whatever the test is, these cases do not meet it.
Obliged, thank you. I thought he said they did, initially, that's why.
Well, he did, but he didn't mean did.
Right, yes, well.
There was an omitted negative,
yes, well.
which we all understood. Now, the very last question, and I'll let you get on in a moment. Sorry to have prattled on so. What you said yesterday was that what happened in practice is that it was convenient to stand jurors by to avoid having to determine subsequently whether or not they should be removed for cause, or presumably whether they should be excused, because it might be possible to select a jury without having to make that determination in relation to any of the jurors stood by. I can understand the practical, quote, wisdom, unquote, of that approach. But doesn't it have the effect that there is, in truth, no random selection of the jurors? Take, for instance, a case where the Crown stands by 6, But in the end, a panel of 12 is constituted. So it's not necessary to go back to consider the 6. The effect of that will be that the 6 will have been excluded simply to avoid the burden of addressing the question as to whether or not they should be excused or whether or not they should be disqualified, which itself is not consistent with a fair trial from an impartial jury randomly selected.
To address that issue, sir, there is a Canadian case, I think it's Chohan, which I'll be dealing with when looking at the question of bias. And the principles from that is that randomness, you want to have to look at the whole jury selection process as a whole. In other words, the actual what happened in the courtroom is just one segment of the whole process, and you have to look at the process as a whole.
Okay, well, we'll get to that, but I'm just giving notice that it's a question that arises in my mind.
Yes. So, for instance, in the Roberts, the majority of the persons who were stood by and eventually excused, looking at the whole process as a whole, it does not undermine the randomness of the selection of the jury.
Right.
In any event, they would have been excused in any event, and we would be right back to where we were.
Well, that is absolutely correct, or potentially correct, if in fact all those stood by first time are reconsidered second time. But in my example, you stand by 6, but you still managed first time, but you still managed to create a jury of 12. You never get round to considering whether the 6 should have been recused or excused.
Yes, sir, but we're back to that general principle of where the court or in the whole process, there was a faithful application of the law at the time, because at the time when the trials took place, there was nothing wrong or deemed to be wrong with jurors being stood by.
Yeah.
Given a reason. So therefore, it is a bit unfair now, and I say this respectfully, that looking with hindsight, the Crown now has to explain what it did and why it did what it did, when at the time when it did what it did, it was lawful and proper. And that's where the principle of finality comes into play as well.
Yeah. Right.
In effect, your submission will be, Mr. Mahoney, if I follow
yes,
that, there has to be something more than the actual operation of the law as it stood at the time.
That is so. And that is what Section 5 in the Amendment Act, the proviso, in a nutshell, that's what it is saying, that the mere fact that the Crown stood by more than 3 by itself is not sufficient to overturn the convictions that were lawfully and properly based. Could I continue or?
Yes, of course. No, please do. I'm sorry.
Oh, sorry. Before continuing, so I just wish to go back to the case of Gov and the governor of Arbor Hill Prison.
Yes.
And I would like to start at page 425 of paragraph 1.
A moment.
This is a judgment of Chief Justice Murray.
Mhm.
Where his judgment starts with the general statement of principle. The fact that a provision was held to be no longer in force since 1937 does not automatically carry the corollary that what has been done under and in pursuance of that provision after the Constitution came into force will necessarily be condemned for lack of validity, per Justice Griffin in Murphy and the Attorney General at page 328. It does not necessarily follow that court orders lack binding force because they were made in proceedings based on an unconstitutional statute, per Justice Enchi in the State, Byrne, and Frawley. While I will return later to the context in which these judicial dicta were pronounced, I mentioned them at the outset so as to highlight the fact that the issue which arises in this case, the retrospective effect on cases already decided of a finding that the provision of an act is unconstitutional, is not a novel one, although it does arise in this case in a novel manner and aptitude for reasons which I will refer to later. I'll ask the court to look at paragraph 11, which is at page 26.
Yes.
Deals with the issue that arose in that case, the issue in the present case. As counsel for the applicant said, his argument in this case is quite simple, and he put it in the following terms. His client was convicted of an offense.
Sorry, is somebody's phone?
Yes, sir.
Hmm.
As counsel for the applicant said, his argument in this case is quite simple, and he put it in the following terms. His client was convicted of an offense under Section 1, subsection 1 of the Act of 1935. That section has been declared unconstitutional pursuant to Article 50 of the Constitution. That means, because of its inconsistency with the Constitution, the provision was never the law in the state after the adoption of the Constitution in 1937. That in turn means it is deemed not to have been the law at the time of his conviction and sentence for the offense. For that reason alone, the final judicial verdict convicting him and sentencing him to imprisonment was null and of no effect. Therefore, he is not detained in accordance with law. It is analogous to the consequence which also flows from a finding that a post-1937 act of the Orectas, yes, is incompatible with the Constitution, which as a consequence of such an act being deemed invalid ab initio, that is to say, that from the date of its enactment and never to have entered into force. He rests his case on the principle of void ab initio exclusively without regard to any other principles deriving from the Constitution. And it is my submission that the submissions of the applicants in this case seem to be in parallel or in tandem with what was put forward by counsel in this case. That because the relevant section of the act was declared unconstitutional, it was unconstitutional ab initio, and therefore any case that were concluded before the declaration of invalidity of the section, therefore is fundamental, to use the term of Mr. Pettingill. It goes to the heart of the defendant's right to a fair trial by an impartial jury. Over at paragraph 30, he continues, and that's at page 228. And in this part of the judgment, under the caption of retroactivity generally in the common law system, the Constitution may, in a certain sense, fall to be viewed from the perspective of the common lawyer, since the Constitution was superimposed on and indeed presumes the existence of the common law system, at least insofar as it is not inconsistent or incompatible with the Constitution itself. I think it would be useful to look at the common law position on the retroactive effects of judicial decisions in previously decided cases. A primary judicial function is to interpret the law, that is to say, the Constitution, legislation, and the common law. As I observe in Crilly and T&J Farrington Limited at page 286, first there is the law, then there is interpretation. Then interpretation is the law. This simplified reference to the judicial process emphasizes that when courts apply a statute, the interpretation which they give it as ultimate authority. One of the consequences of this judicial process is obvious. The meaning or import of law is interpreted and defined incrementally. It is also important to bear in mind, as in the present application, that the courts cannot and do not choose the legal issues of interpretation or otherwise, which they have to decide. They can only decide such issues when they are raised in the context of judicial proceedings brought before them. Thus, the conventional manner in which the law has been applied in a particular era for many decades may be greatly altered, even turned on its head as a result of a particular issue being raised in a particular case at a particular point in time, leading to an extension of the law by reference to general principles. The overriding of precedent or the specific interpretation of a provision of a statute which gives it a meaning different from that which had been commonly held. The decision of this court, which decided that failure to wear a seatbelt could constitute contributory negligence, did not entitle already decided cases to be reopened. One could give many other examples, and I will just mention two seminal cases. First, in Donoghue and Stevenson, as adopted and followed by this court, which extended the duty owed by manufacturers of unsafe goods beyond the ambit of those with whom the manufacturer had privity of contract to ultimate consumers who were entitled to sue on the grounds of the manufacturer's negligence. This did not lead any more than other leading decisions in the field of contract or tort, and so on, to the reopening or setting aside of finally decided cases. The law did not permit other parties to challenge the finality of already decided cases concerning manufacturers' liability. The second example in Byrne and Ireland, which determined for the first time that the state Ireland was vicariously liable for the negligent or tortious acts of public servants and did not benefit from any so-called prerogative of immunity from suit claimed to be attached to the state in its sovereign status. That was the meaning given to the Constitution and a fortiori since its enactment in 1937. The plaintiff was therefore entitled to recover damages from Ireland for any injuries which she suffered as a result of falling on a footpath which had subsided due to excavation works carried out by the Department of Posts and Telegraphs. It did not mean in law, and no one has or was ever likely to suggest, that any persons who had previously brought a similar unsuccessful case against a minister or the state, or indeed who had confined themselves to suing the only person it was thought they could sue, the actual public servant who committed the tort, with a risk or likelihood that he or she would not have means to pay damages awarded, or at best only partially to do so, could, in the light of the ruling, set aside any previously decided cases or reopen them. The common law, sir.
Can you somehow remove that phone?
Could you stop calling this number, please? Sorry about that, sir.
Mm-hmm.
The common law is never conceived as consistent with any ordered administration of justice, that previously decided and finally determined cases could necessarily be set aside or reopened in the light of a new precedent, notwithstanding the historical view of the common law expressed by Blackstone in his commentaries that judges discover the law as it truly is, and that overruled precedents were misrepresentations of the law and were never law. For it is to be found that the former decision is manifestly absurd or unjust. It is declared, not that such a sentence was bad law, but that it was not law. Blackstone's Commentaries 169. In modern constitutional systems, we have moved on from that perception of the law, at least in its purest form. But even when viewed through Blackstone's prism, the common law did not envisage absolute retroactivity of judicial decisions and did not permit previous cases, even though finally determined on principles that were never law, to be reopened. As Judge Richard Posner, writing exjudicially, observed, pure retroactivity is rare. Problems of Jurisprudence, 1993. Judicial decisions which set a precedent in law do have retrospective effect. First of all, the case which decides a point applies it retrospectively in the case being decided, because obviously the wrong being remedied occurred before the case was brought. A decision in principle applies retrospectively to all persons who, prior to the decision, suffered the same or similar wrong, whether as a result of the application of an invalid statute or otherwise, provided, of course, they were entitled to bring proceedings seeking the remedy in accordance with the ordinary rules of law, such as a statute of limitations. It will also apply to cases pending before the courts. That is to say that a judicial decision may be relied upon in matters or cases not yet finally determined. But the retrospective effect of judicial decision is excluded from cases already finally determined. This is a common law position. Only a narrow approach based on absolute and abstract formalism could suggest that all previous cases should be capable of being reopened or relitigated, even if subject to a statute of limitations. If that absolute formalism was applied to the criminal law, it would in principle suggest that every final verdict of a trial or decision of a court of appeal should be set aside or, where possible, retried in the light of subsequent decisions, where such subsequent decisions could be claimed to provide a potential advantage to a party in such a retrial. In principle, both acquittals and convictions could be open to retrial, but one has only to pose a question to see the answer. No one has ever suggested that every time there is a judicial adjudication clarifying or interpreting the law in a particular manner, which could have had some bearing on previous and finally decided cases, civil or criminal, that such cases be reopened or the decision set aside. It has not been suggested because no legal system comprehends such an absolute or complete retroactive effect of judicial decisions. To do so would render a legal system uncertain, incoherent, and dysfunctional. Such consequences would cause widespread injustices. As Justice Enchi stated in Murphy and the Attorney General at page 314, incidentally, when addressing the effects of a law declared unconstitutional ab initio, over the centuries, the law has come to recognize in one degree or another that factors such as prescription, negative or positive, waiver, estoppel, laches, a statute of limitation, res judicata, or other matters, most of which may be grouped under the heading of public policy, may debar a person from obtaining redress in the courts for injury, pecuniary or otherwise, which would be justiciable and redressable if such considerations had not intervened. To take but two examples, both from a non-constitutional context, where a judicial decision is overruled by a later one as being bad law, the overruling operates retrospectively, but not so as to affect matters that in the interval between two decisions became res judicata in the course of operating the bad law. The words of Justice Enchi, and I will be referring more fully to this passage later, reflect the reality of what the law discovered long ago. There are, as he also stated in his judgment, transcendent considerations which militate against complete or absolute retrospectivity. Fundamental interest of public policy requires limitations on the retroactive effect of judicial decisions. The legal order and the administration of justice is not one of perfect symmetry. As Justice Benjamin Cardozo observed at page 161 in his seminal work, The Nature of the Judicial Process, Yale University Press, 1921, we like to picture to ourselves the feel of the law as accurately mapped and plotted. We draw our little lines and they are hardly down before we blur them. Although judicial adjudications do have retroactive effect, there are important exceptions and restrictions to that effect. A line must be drawn in the interest of justice. Speaking of a rule limited retroactive effect of judicial decisions, once again, Justice Cardozo observed, it may be hard to square such a ruling with abstract dogmas and definitions. When so much else that a court does is done with retroactive force, why draw the line here? The answer is, I think, that the line is drawn here because the injustice and oppression of a refusal to draw it would be so great as to be intolerable. The law is too old and too wise to be applied according to a rigid abstract logic or a beguiling symmetry. As Justice Enche pointed out above, for centuries, the law has known general principles and transcendent considerations, such as the public interest, which is another way of saying the common good, restricting retrospectivity, especially the setting aside of judicial decisions already finally decided, even though the law on which they are founded is later held to be invalid. It has never been held, and as far as I am aware, never been argued, the matter might well be considered beyond argument, that the common law rule that judicial decisions do not retrospectively apply to cases already decided is in any way inconsistent with the Constitution. The argument of counsel for the applicant was as simple as it was stark. The applicant stands convicted and sentenced on a law that does not exist. Although counsel elaborated on this argument that that is its fundamental essence. If it is correct, it is one which is out of kilter with the underlying common law system. It may come as no surprise to find that it is also out of kilter with other constitutional systems, and in particular with our own. And it goes into look at other legal systems.
Yes.
It is judgments in the state, Crowley and Murphy and the Attorney General, Justice Enche found it helpful to refer to the law of the United States and the European communities as evidence of the principle that what has been done or left undone under a constitutionally invalid law may be impossible or unjust or contrary to the common good to reverse or undo. I would like to refer to the position in a number of legal systems which are cogent examples of the principle referred to by Justice Enche, European Union. In successful proceedings before the European Court of Justice challenging the validity of community regulations, pursuant to Article 230 of the European Community Treaty, the court is required under Article 231 to declare the measure concerned void. In principle, this means that the measure never entered into effect, but the latter article also provides that the Court of Justice shall, if it considers this necessary, state which of the effects of the regulation which it has declared void shall be considered as definitive. On the direct basis of that provision, the court has limited the retrospective effect of a declaration that a measure is void, including by maintaining the provision in effect until a new valid measure has been adopted, sometimes specifying that this must be done within a reasonable time. See, for example, Commission and Parliament, and the case number is there. But the court may also review the validity of a community legal measure outside the ambit of Article 231 in response to a request for a preliminary ruling by a national court. In order to maintain legal certainty and consistency, the court has found it necessary to apply, by way of analogy, a similar approach to declarations of annulment in such cases. Moreover, as the Court of Justice has repeatedly stated, when it gives a decision on the meaning and scope of community law, it is that which it must be or ought to have been understood and applied from the time of its coming into force. in that, well, si administrazione della, I think that's an Italian case.
Delle finanze dello Stato.
Oh, thank you, sir. In that case, also repeated at paragraph 17, is its oft-stated principle, which acknowledges that exceptionally the court may, in application of the general principle of legal certainty inherent in the community legal order and in taking account of the serious effects which its judgments might have as regards the past on legal relationships established in good faith, be moved to restrict for any person concerned the opportunity of relying upon the provisions as thus interpreted with a view to calling in question those legal relationships. Emphasis added. In exercising such a general discretion, the Court of Justice, as Advocate General Stix Aki recalled in her opinion delivered on the 14th of March 2006 in Banco Popolare de Cremona and Agencia Entrate Justicio Cremona, and courts has taken various approaches. Has taken various approaches. In some cases, it is specified that the finding of invalidity has no retroactive effect whatever. In other, it has stated that the effect is in general not retroactive, but has allowed retroactive effect for those who have, before the date of the judgment, brought proceedings based on the invalidity. In the case law, the Court of Justice has clearly considered that limitations on retrospective effect of its decisions were necessary in the interest of legal certainty and the coherence of the community legal system. In Murphy and the Attorney General, Justice Enchi viewed specifically that approach of the Court of Justice as a cogent example of the general principle of limiting retrospective effect of decisions in such circumstances, notwithstanding the particular features of the community legal system. European Convention on Human Rights. The European Court of Human Rights, in exercising its jurisdiction to protect fundamental rights under a convention reflecting the common heritage of freedom and the rule of law of now 46 European countries, found it appropriate and necessary to limit the retrospective effect of its judgments on fundamental issues of human rights in the interest of legal certainty and the due administration of justice. This approach was also prompted, at least in part, by the fact that it interprets the convention in the light of present conditions, which is analogous to one aspect of the interpretive approach of this court to the Constitution of Ireland, to which I refer later. In Maresque and Belgium, paragraph 58, a case which condemned a Belgian law because it wrongly deprived children born out of wedlock of inheritance rights. The court, having cited the case law of the Court of Justice of the European Community, stated at page 353, the European Court of Human Rights interprets the convention in the light of present-day conditions, but it is not unaware that differences of treatment between illegitimate and legitimate children, for example, in the matter of patrimonial rights, were for many years regarded as permissible and normal in a large number of contracting states. See Mutatis Mutandis, paragraph 41 above. Evolution towards equality has been slow, and reliance on the convention to accelerate this evolution was apparently contemplated at rather late stage. Having regard to all these circumstances, the principle of legal certainty, which is necessarily inherent in the law of the convention, as in community law, dispenses the Belgian state from reopening the legal acts or situations that antedate the delivery of the present judgment. Moreover, a similar solution is found in certain contracting states having a constitutional court. Their public law limits the retroactive effect of those decisions of that court that annul legislations. Emphasis added. Even though the European Court of Human Rights condemned the Belgian law because it breached the fundamental rights of the applicant because of a restriction on her inheritance rights as a child born outside of wedlock, it found it not only accepted, but it not only acceptable, but necessary to limit the retrospective effect of its decision in the interest of a fair and current administration of justice, rather than permit it to be distorted by the abstract concept of absolute retrospectivity. In doing so, it followed the norms of constitutional adjudication in other European countries. India, Supreme Court of India, in addressing a similar issue, after having declared a statute invalid, stated in Orissa Cement Limited and State of Orissa, 1991, declaration regarding the invalidity of a provision and the determination of the relief that should be granted in consequence thereof are two different things. And in the intersphere, the court has and must be held to have a certain amount of discretion. Once the principle that the court has a discretion to grant or decline refund is recognized, the ground of which such a discretion should be exercised is a matter of consideration for the court, having regard to all the circumstances of the case. The court can grant or restrict the relief in a manner most appropriate to the situation before it, in such a way as to advance the interests of justice, emphasis added. It is worth noting that the Supreme Court of India deduced its inherent power to restrict the retrospective effect of its judgments, declaring a statute to be unconstitutional in circumstances where Article 13.1 of the Constitution of India, under the heading of laws inconsistent with or in derogation of the fundamental rights, provides that laws in force immediately before the commencement of this Constitution, insofar as they are inconsistent with the provisions of this part, shall to the extent of such inconsistency be void, and goes on in paragraph 2 of that article to state that the state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of the contravention, be void. It is interesting to note a substantial correspondence between the provisions of Article 13.1 and 2 of the Indian Constitution and Article 15.4 and 50.1 of the Irish Constitution, and that of the Indian Constitution is more explicit as to the void nature of the legislation in question. It is also of interest that the Indian Supreme Court, in exercising its constitutional jurisdiction, like other jurisdictions, differentiated between the notions of void ab initio and the judicial effects, in particular, retrospective effect of its judgments on such issues. It is true that the Indian Supreme Court, in adopting this approach, called in aid the otherwise unrelated Article 142 of the Indian Constitution, which enables the court to make such order as is necessary for doing complete justice in any court or matter pending before it. Nonetheless, it is clear that the Indian Supreme Court felt it necessary to derive from this article an implied power to limit retrospective effect in order to bring certainty and coherence to the administration of justice, notwithstanding that its constitution expressly provided that unconstitutional enactments were void and not just voidable. United States. In the United States, the Supreme Court, in addressing both the retrospective and prospective effects of its judgments on such issues, was not, as Justice Enshi pointed out in Murphy and the Attorney General, encumbered by the kind of provisions to be found in Articles 15.4 and 50.1. Nevertheless, as regards the general principle, he went on to cite with approval from the opinion of the United States Supreme Court in Chilcot County Drainage District and Baxter State Bank, the following passage. The courts below have proceeded on the theory that the act of Congress, having been found to be unconstitutional, was not a law, that it was inoperative, conferring no rights and imposing no duties, and hence affording no basis for the challenge decree. None and Shelby County and Chicago INL Riley Company and Hackett. It is quite clear, however, that such broad statements as to the effect of a determination of unconstitutionality must be taken with qualifications. The actual existence of a statute prior to such a determination is an operative fact and may have consequences which cannot justly be ignored. The past cannot always be erased by a new judicial declaration. The effect of the subsequent ruling as to invalidity may have to be considered in various aspects with respect to particular relations, individual and corporate, and particular conduct, private and official. Questions of rights claimed to have become vested, of status, of prior determinations deemed to have finality and acted upon accordingly, of public policy in the light of the nature both of the statute and of its previous applications demand examination. These questions are among the most difficult of those which have engaged the attention of courts, state and federal, and it is manifest from numerous decisions that all-inclusive statement of a principle of absolute retroactive invalidity cannot be justified. Although the United States Supreme Court was not governed or encumbered by the provisions of Article 15 or 50, it is recognized that even where in principle a statute was unconstitutional and not law, it nevertheless was compelled in the interest of legal certainty to engage in the complex exercise of balancing the competing considerations of a law being void and limitations on absolute retrospectivity. The case law of the United States Supreme Court in relation to criminal cases was developed in Linkletter and Walker, in which the court drew the line or limit on retrospectivity to cases in which judgments of conviction were not yet final, so that only persons in those situations could rely retrospectively on the subsequent decision. In Tian and Schott, the United States Supreme Court reaffirmed the fundamental principle set out in Linkletter and Walker, that the application of a rule against absolute retrospectivity in the constitutional era, where the exigencies of the situation require such an application, pose no insufficient, constitutional or philosophical. Insofar as there has been judicial debate on this issue in the United States, insofar as there has been judicial debate on this issue in the United States Supreme Court, it has focused not so much on the existence of such a rule, but rather to what extent there may be exceptions, if any, to it in particular circumstances. United States jurisprudence was further developed in subsequent case law, including Stovall and Deno, but the current position is summed up in annotated constitution prepared by the Congressional Research Service at the Library of Congress, which states at page 685. The court has now drawn a sharp distinction between criminal cases pending on direct review and cases pending on collateral review. For cases on direct review, a new rule for the conduct of criminal prosecution is to be applied retroactively to all cases, state or federal, pending on direct review are not yet final. Thus, for collateral review in federal courts or state courts, criminal convictions, the general view is that new rules of constitutional interpretation announced after defendant conviction has become final will not be applied. Thus, applications for habeas corpus based on a judicial decision subsequent to a conviction becoming final and not otherwise under direct appeal or review fall into the category of collateral review and therefore not entitled to rely on new rules of constitutional interpretation according to the annotated constitution. The only exceptions are for decisions placing certain conduct for defendants beyond the reach of the criminal law and for decisions recognizing a fundamental procedural right without which the likelihood of an accurate conviction is seriously diminished. That's Teague and Lane. Canada. In Canada, Section 52.1 of the Canadian Constitutional Act, 1982, has a substantial correspondence to Article 50 of our Constitution, in that it provides that any law that is inconsistent with those provisions is, to the extent of such inconsistency, of no force or effect. As counsel for the respondent has pointed out, the Canadian Supreme Court has, notwithstanding those provisions, asserted a jurisdiction to suspend a declaration of unconstitutionality and apply temporal limitations, limiting or restricting altogether its retrospective effect. In the Queen and Bain, which we have heard a lot about in this case, which condemned aspects of the jury selection system, the court suspended its declaration for some 6 months. In the Queen and Wigman, the Canadian Supreme Court held that a decision determining the invalidity of a statute on unconstitutional grounds could not be relied upon in criminal cases previously decided, which were not still pending before the court and which had been finally decided. In that case, the court stated at page 257, finality in criminal proceedings is of the utmost importance, but the need for finality is adequately served by the normal operation of res judicata. A matter once finally judicially decided cannot be relitigated. Thus, a person convicted will not be able to reopen his or her case unless, of course, the conviction is not final. In the reference, we Manitoba language rights, the court observed that res judicata would even preclude the reopening of cases decided by the courts on the basis of constitutionally invalid laws. This res judicata principle would apply with at least as much force to cases decided on the basis of subsequently overturned case law. Sorry, I'm just checking where I am with the time.
Yes.
I would just like to move on. The case of Stephen Grant in Jamaica.
Yes.
That case did review some Australian authorities on the point. And Stephen Grant is at page 73.
The supplemental bundle of authorities, is it?
Yes, sir. Thank you, sir.
Moment.
Specifically at paragraph 29, that's at page 85.
Just a moment, I'm trying to find it. Yes, sorry, what are we to look at?
Paragraph 29, it's at page 85.
Yes. Yep.
Under the subheading, the jurisdiction to reopen an appeal, which has already been determined. The applicant, not being a first-time appellant, what then are the principles, if any, which guide the court when an appeal has already been heard and determined and the applicant desires his appeal to be reopened? I'll go down to paragraph 36.
36.
Yes. I would invite the court to read the whole case, but I'm just picking out the relevant paragraphs in the interest of time. So at paragraph 36, it is clear, therefore, that this court has jurisdiction to correct a clerical error, accidental slip, or omission in its judgment or order in the circumstances outlined above. But there is no jurisdiction to rehear an appeal or alter judgment or order after it has been passed and entered, provided it accurately reflects the intention of the court. There is also no jurisdiction to open a concluded appeal to revisit an order the court intended to make, but which it ought not to have made. Paragraph 37, there is power to order that an appeal be relisted where there has been an irregularity or something akin to fraud or mistake alleged of such a nature as to cause this court, in the exercise of its inherent jurisdiction, to declare the first order on appeal a nullity. Otherwise, the court is functus officio. Going down to paragraph 43.
Could you just remind me which court this is?
This is the Jamaica Court of Appeal.
Yes, thank you.
2018 decision. Paragraph 43. In the consolidated case of Reginon Pedley, Reginon Martin, Reginon Amadi, 2009, 1 WLR, the Court of Appeal of England and Wales, Criminal Division, in considering the case of Regina and Amadi, considered the very limited power it had to rear a concluded appeal. It found that it had the power to relist an appeal where by administrative error or otherwise the appellant was deprived of a proper hearing so that the apparently concluded hearing could properly be described as a nullity. This, it said, included cases where the Court of Appeal failed to follow the rules or well-established procedure. The Court of Appeal considered the Queen and Daniel to be a good example and found that there was no exception to the case before it. The case of Regina and Amadi, it found, was simply a case where counsel had second thoughts and wished to argue a point not taken when the appeal was fully heard. In part, counsel in Regina and Amadi wished to argue the same point argued previously. The Court of Appeal held that the jurisdiction did not exist, and if it did, every disappointed appellant could seek a second hearing or it may be supposed a third or a fourth. In the Queen and Hussein, I think Mr. Lynch had made reference to this case in his submissions. In the Queen and Hussein, the Court of Appeal was asked to rule on its power to reopen an appeal to correct an error, which was said to have caused a real injustice, in that a sentence lawfully imposed by the Crown Court was quashed because of a perceived error. It was later discovered that the error was not in the judgment, but in the transcript. The Court of Appeal held that once the judgment was entered and recorded, it could not be amended. However, the Court of Appeal identified two exceptions to this. The first was that the court does have the power to hear an appeal if, on proper analysis, the previous order was a nullity or there was such a defect in the procedure that it may have led to some real injustice. Looking further afield to the jurisdiction of New South Wales, notably similar principles apply. The case of the Queen and Burrell, 2007, NSWCCA 79 provides a detailed analysis of the factors that must be considered when assessing whether an appeal should be reopened. In the Queen and Burrell, the Court of Criminal Appeal delivered its judgment dismissing an appeal that was brought. That order was entered by the registrar of the Court of Criminal Appeal without a request from the parties on the same day. The Crown thereafter made an application to the court that it should, in the interest of justice, reopen the appeal on the basis that the understanding which the court had of evidence at the trial was in some respects incorrect. Mr. Burrell submitted that the court, as constituted, did not have jurisdiction to entertain the Crown's application. He also submitted that in order to avoid any apprehension of bias, the Crown's application should be heard by a court of criminal appeal differently constituted. Chief Justice McClellan opined that a review of the relevant authorities indicated that the extent of the jurisdiction of a court of appeal to open a matter which had been heard and orders made had received consideration on a number of occasions. Chief Justice McClellan observed that although there was a fundamental public interest in the finality of litigation, the courts have also been concerned to ensure that parties receive a fair hearing and a determination of the matter upon its merits. The Chief Justice noted, however, that particular difficulties would arise when the orders have been perfected. In coming to the decision that the appeal was not finally determined because the matter was not determined in relation to the relevant evidence, Chief Justice McClellan stated the following: in this case, the appeal has been determined and reasons published upon a false understanding as to some matters. The appeal has not been determined in relation to the relevant evidence. For that reason, it has not been finally determined. If the matter is to be determined on its merits, that evidence and that evidence only must be considered. The circumstances of this case are exceptional. Public confidence in the criminal justice system depends upon courts making decisions which, so far as possible, are based upon the relevant facts to which the correct legal principles have been applied. In my opinion, this court should intervene, recognize the errors, and determine the matter having regard to the correct understanding of the facts and provide reasons accordingly. The Chief Justice referred to a plethora of cases that may play a pivotal role in assisting the court in deciding whether the orders the applicant seeks in his several applications should be granted. The starting point is Grierson and the King, 1938, 60 CLR 431. In Grierson, the High Court opined that no court has authority to review its own decision pronounced upon a hearing inter partes after the decision has passed into judgment formally drawn up. Grierson and the King was considered in Jones and the Queen, 1989, 166 CLR 49. The problem, as seen in Jones and the Queen, was that the appellate court had not considered all of the appellant's arguments. The argument in the High Court on an application for special leave to appeal proceeded on the footing that because the order of the Court of Criminal Appeal had been perfected, it was not possible to again move the Court of Criminal Appeal to determine grounds of appeal which had been left undetermined. The High Court, however, expressed regret that the Court of Criminal Appeal had not been approached before the order had been perfected, granted special leave to appeal, and remitted the matter to complete the hearing and determine the appeal. The question was again considered in Pantorno and the Queen, 1989, 166 CLR 466. In that case, special leave to appeal to the High Court was sought on a ground which had not been argued in the court below. The High Court emphasized that failure to argue a point in the Court of Criminal Appeal would present a considerable obstacle to an applicant seeking special leave to argue in that court. The court recognized that a court of criminal appeal may have to give further consideration to issues which were relegated to the margin of attention during the argument, though it is not required to consider new grounds which counsel abstained from raising on the appeal. The court ultimately held that a failure to consider the additional grounds had the consequence that the appellant had been denied natural justice. In the Queen and Lapa number 2, 1995, 88 Crim R, the applicant complained that the Court of Criminal Appeal had not determined one of the grounds of appeal. That application had been made before the order had been entered. However, entry of the order occurred after the application was made. The Court of Criminal Appeal was satisfied that it could review its judgment at any time until its order had been perfected. It further held that the power of the court was not lost by the administration which perfected the order after the application to reopen had been made. In the Queen and Gus, it was held that the court had the power to grant an application to reopen the hearing of an appeal if an applicant could show that he had been denied procedural fairness, even after the judgment had been perfected. The appellant in the Queen and Geary number 2 argued that he had been denied natural justice by the Court of Criminal Appeal. He applied to have the appeal reopened and further submissions considered. Although the court rejected the application, Justice of Appeal Haydon held that it is clear that an appellate court may reopen a case which has already been decided if it was decided on a point on which the losing party has, without personal fault, not been heard. Autodesk Inc. and Dyson. It is also the case that an appellate court may reopen a case which has already been decided on other grounds. But however, emphasize that according to Wentworth and Walhara Municipal Council 1982, in practice, the circumstances are extremely rare. The public interest in maintaining the finality of litigation necessarily means that the power to reopen to enable a rehearing must be exercised with great caution. Chief Justice McLennan in the Queen and Burrell noted that in the Queen and Reardon, Justice of Appeal Hodgson reviewed several authorities and expressed the view that what was said in Jones and the Queen and Pantorno and the Queen was insufficient to displace the binding order of Grierson and the King, to the effect that once an appeal has been heard and determined and the order perfected, there is no jurisdiction to reopen the appeal. It was stated, however, that the above ratio is subject to the slip rule and the possibility of separate proceedings to set aside orders obtained by fraud. It also accepted that the principle applies when an appeal has been heard and determined, and leaves open the possibility that if there are grounds of appeal which are not determined at all, it could be said that the appeal has not been determined. In the Queen and Carrion, in considering the problem in the context of a slip, the court carried out a comprehensive review of the authorities. This included the decision of the Queensland Court of Appeal in the Queen and Allen. In that case, the court held that it had inherent jurisdiction to vary an order which it had originally made so as to allow an appellant to argue a further ground of appeal. This was done although the order and appeal had been perfected. Chief Justice Wood recognized that the court's jurisdiction, which he described as inherent, in the fact that the interests of justice required the court's intervention. I would just skip down to paragraph 59, where the principles are summarized. The issue is therefore not without precedent. The general principles to be gleaned from the cases are that A, generally there is power to relist or reopen an appeal which has been determined and orders made outside of any relevant statutory provisions and slip rule. B, there is limited jurisdiction in the Court of Appeal based on its inherent jurisdiction to control its process to relist or reopen an appeal and alter the order of the court before the order is perfected on the record. C, where the appeal has been determined and the order of the Court of Appeal has been perfected, there is generally no power to reopen an appeal. D, an appeal which has been determined and the order perfected will not be relisted or reopened unless there has been a defect in procedure or an irregularity amounting to fraud or mistake which had caused the previous hearing to be annulled. E, the court has the jurisdiction only in exceptional cases to reopen a determined appeal where it considers that there is a likelihood of substantial injustice to the appellant if it does not intervene. Those exceptional cases include but are not limited to circumstances where the appeal was decided on a point on which the applicant was not heard. There were grounds of appeal which were argued but were not determined by the court so as to raise the issue of whether the appeal was finally determined or not. And three, the appeal was a procedural nullity. F, neither a change in the law or fresh evidence by themselves will be sufficient for the appellate court to reopen the case. The general principle, therefore, subject to the limited exceptional circumstances, is that an appellate court has no authority to review its own decision pronounced after a hearing inter partes where the decision has passed into a judgment which is formally drawn up. This principle is one that is strictly enforced and is deviated from in limited exceptional circumstances only. The applicant must not only place himself in one of the limited exceptional circumstances, but the injustice which would be meted out to him if his appeal is not reopened must be so substantial as to far outweigh the public interest in the finality of litigation. I skip down to paragraph 101. I think I've covered that paragraph already.
Sorry, which page is that on?
Yes, it's at page 118. The question of retrospection was marginally considered by the Privy Council in Ruddock and the Queen, and during its decision to overrule the case of Shang Win Sui and the Queen, and to restate the law on foresight and intent with respect to secondary parties, the board considered the impact this change in the law might have on past convictions. It said that the effect of putting the law right was not to render invalid all convictions which were arrived at over many years by faithfully applying the law as it was laid down in Shang Win Sui and the Queen. It also held that where convictions had been arrived at by faithfully applying the law as it stood at the time, it could only be set aside by seeking.
I think we've seen this, haven't we?
Yes, we have gone through this before. And
I don't think.
Close with paragraph 102. That's page 120. In this instant case, the question of retrospection arises because judicial decision, since the applicant's case was decided, must be that a judge must give full credit for time spent in custody, and the judge is departing from the principle of full credit, he or she should give reasons. We take the view, however, that this change by itself is not sufficient ground to reopen a determined appeal unless the applicant can show that as a result of the change, he would suffer substantial injustice if his case was not reopened. I would now wish to go to the Canadian case of Canto.
What was the result in Grant?
In respect of Grant, his attempt to rope the appeal was refused. The decision is bottom of the judgment. His application was refused, sir. Paragraph 204, page 129.
Say it again.
Is that page 129? Is the decision of the court? The application to vary or discharge order of a single judge is refused. The application for extension of time to file appeal against sentence is refused. Application for permission to appeal against sentence is refused.
And what basically had he been saying? I've rather forgotten.
Oh, he was saying that because there was a change in the law that the judge, well, it's at paragraph 101, I think. In a nutshell, there was a change in the law that in regards to sentencing, the judge should take certain things into account. And he was saying that in regards to his sentencing, those procedures were not applied. And accordingly was seeking to have his appeal reopened in light of the change in law. With your permission, may I proceed to the case of Thomas, and that's in the respondents' supplemental submissions addendum.
Just a moment. Just a moment. Just a moment. Just a moment. Where is this? I'm so sorry, I can't find it. It's in where? Oh, I've got it. Wait a minute.
I think Mr. Quayler said it's in this supplemental.
It's in the joint authorities bundle, my lord. You go into the joint authorities bundle on the cloud, and there's a tab that was uploaded about an hour ago, and it's entitled Respondent Submission, the Queen and Thomas.
Just a moment.
First page.
Has it got a tab number?
On the document itself, it says 19, but that's in the electronic version.
Yes, correct. That's correct, my lord.
I have it in hard copy as tab 20.
That's correct.
Oh. I'm so sorry, what?
I think it came by email attachment today, did it, Mr. Quayler?
That's correct. I'm just trying to give you a time approximation.
Well, I've got a document which is Respondent Submissions Ray Thomas.
Yes, that's it.
Yes.
All of the submissions are in that for the respondent that was sent.
But how do I get to? How do I get to the authority?
What is the name of the authority, Mr. Mahoney?
Thomas?
Yeah.
Well, more so Canto. I want to rely on Thomas and Canto, but if we have a problem with Thomas, I could go straight to Canto.
Wait a moment. Yes, I've got Thomas now.
Cantu is 3 pages down.
Yeah. Yeah. Thomas.
My learned friend, Mr. Lynch, actually submitted the case of the Queen and Sarson. He did not make any submissions on it, but he did invite the court to consider all his authorities and his submissions. And our submissions in respect of Sarson is.
What are you saying about Thomas, Mr. Mahoney?
Oh, that's where I'm going with Thomas.
I see.
Sarson should be viewed in its proper context, and it undermines the appellant's submissions and actually strengthens the respondent's case. In Sarson, Justice Sopinko delivered the decision of the Supreme Court of Canada, which applied the case of the Queen and Thomas, a case in which he also delivered the decision of the court. In the latter case, the applicant was convicted of second-degree murder. I think it's a one-page or two-page decision.
I'm sorry, where are you reading from something?
Now I'm reading from my submissions, respondent supplemental submissions. Dated the 5th of March, filed the 5th of March.
So are you taking us to Thomas?
Yes, shortly, but I'm just making my submissions. And
Right.
then I go to Thomas. So going back to Thomas, in the latter case, the applicant was convicted of second-degree murder in 1984. His appeal was dismissed on the 27th of January, 1987. 3rd of December 1987, the provision of the criminal code under which he was convicted was declared invalid in the case of Valancourt. His application for extension of time to appeal his conviction was refused as he was not in the judicial system. And if we go to the case of Thomas, it's pretty much there on that page. Yeah. So the Canadians have the procedure. Well, Cantor is a case that really shows you how Thomas and Sarson comes together in the case law. So can we now go to the case of Cantor, 2015 ABCA?
Where is that to be found, Mr. Moore?
Ms. Kingdean?
Is it in the same bundle?
Yes, it is. It's
It should be
immediately following the Thomas.
underneath Thomas.
Sorry?
It should be underneath Thomas.
Yes.
Page 3 of the same bundle.
Yeah.
Uh,
My bundle hasn't got pages. Right.
My lord, I'm actually relying on my hard copy and asking my colleague, Ms. Kingdean, to assist me on the electronic copy in regards to the page note. I'd like
Well,
to.
the trouble is
We
the
don't actually
electronic
have page numbers.
doesn't have page numbers.
Okay, could you assist Ms. Kingdean with paragraph 22? Where is it found? In the
2022,
yes.
that would be on
Page 8.
page 8, correct.
Okay, thank you.
Cantor itself.
Oh, I see. There's some page numbers at the top. Yeah.
Yes.
Yes.
Right.
So in respect of Cantor, I'll be relying on paragraphs 22 to 31. And it states as follows. The general principle is that once a judgment is entered and the appeal period has expired, the decision is final. The doctrine of res judicata prevents the parties from relitigating or collaterally attacking any of the issues that have been resolved. In the Queen and Sarson 1986 2 SCR 223 at paragraph 34(5), the litigants are only allowed to challenge a judgment while they are in the system, which means that an appeal has been launched or the appeal period has not yet expired. Queen and Widman, Queen and Thomas. An applicant who perceives he has missed a development in the law will rely on the sense of injustice that he feels because he might have received a lower sentence if he had chosen to appeal. In a system dedicated to the delivery of justice, this is a tempting argument, but the need for finality is equally compelling. The law must balance the advantages of finality with the need to respond to clear miscarriages of justice. The court always has a discretion to permit a late appeal, but should do so only when the principles reflected in cases like Cairns are respected. Permitting a late appeal whenever there might be some possible benefit to the appellant would undermine the competing principle of finality and would reflect too open-ended a test. The legal presumption is that after the expiry of the appeal period, the accused has no right of appeal. Exceptions to that presumption must be based on something beyond an open-ended preference for liberty or fair process, which is a wholly impractical dream. So Wigman at paragraph 21. That approach amounts to a reversal of the presumption of finality, not a principled exception to it. The doctrine of finality is of equal importance to the Crown and the accused. An accused who has been acquitted cannot be tried again. After expiry of the appeal period, the Crown cannot seek to reopen an acquittal or conviction on a lesser unincluded offense based on a later change in evidentiary or substantive law. Nor could the Crown seek a harsher sentence based on later changes in sentencing law. Given their obvious importance, some of these aspects of finality are reflected in section 11G, H, and I of the Charter. The applicant's argument is essentially that the law at the time of his sentence entitled him to enhanced credit, but through some type of oversight, ignorance, or error, he was treated too harshly. He does not argue that Summers changed the law, but rather that Summers confirmed what the law had always been. There has long been a philosophical debate about whether judges make new law or merely declare the law as it always was. For example, Clenworth, Benson Limited, and Lincoln City Council, 1998, 1992, 2AC 349, at pages 358, 378 to 9. This is a sterile debate because the law is frequently uncertain and often evolving. The boundary between change and clarification is imprecise. Whatever may be the correct view, the legal system cannot routinely reopen judgments because of later developments in the law. The presumption is that a person whose case is not still in the system is not entitled to the benefit of new developments or changes in the law after conviction and sentencing. A person like the applicant is not considered to be in the system just because he's still in custody and therefore suffering the effects of the judgment. If being subject to the consequences of a judgment were an exception to the doctrine of res judicata, the doctrine would essentially disappear. In this context, a person seeking leave to appeal late is actually seeking leave to enter back into the system, contrary to the general presumption that judgments are final once the appeal period has expired. In Wigman, the appellant had been convicted of attempted murder. 3 years after the trial, the Supreme Court modified the mens rea requirement for that offense. Wigman had an appeal outstanding based on other issues, so he was still in the system. He applied to raise this new issue in his existing appeal, arguing that under the most recent statement of the test, the change to the jury in his case, the charge to the jury in his case was now known to be erroneous. The court encapsulated the issue as follows. The appropriate test is whether or not the accused is still in the judicial system, as expressed in the Crown's factum. This test affords a means of striking a balance between the wholly impractical dream of providing perfect justice to all those convicted under the overruler authority and the practical necessity of having some finality in the criminal process. Finality in criminal proceedings is of the utmost importance, but the need for finality is adequately served by the normal operation of res judicata. A matter once finally judicially decided cannot be re-litigated. Since Wigman was still in the system, he was not precluded from raising the mens rea issue, even though it arose for the first time before the Supreme Court of Canada. In Thomas, the appellant was convicted of murder, and the British Columbia Court of Appeal dismissed his appeal on other issues. About 10 months later, the constructive murder provisions were held to be unconstitutional. Almost 3 years after his original appeal was dismissed, the appellant applied for an extension of time for leave to appeal to the Supreme Court of Canada. The court weighed the competing objectives of fairness and finality. In a case in which the applicant alleges that he or she was convicted under a provision which has since been declared invalid, he or she should not be placed in a worse position than any other applicant. On the other hand, since we cannot do perfect justice, the applicant should not artificially be brought into the system. The court denied the application because there was no intention to appeal before expiry of the appeal period, and the delay in seeking relief had not been adequately explained. I pause here a bit because I think my learned friend, Mr. Lynch, was seeking to rely on the case of Sarson to say that, oh, they are in the system because leave to appeal was granted. Based on, in the proper context of this case, Canto, as this issue arose in the Canadian jurisprudence, leave to appeal would not have been granted because from their approach, to be reinserted into the system would be artificially being placed in the system and not a real being in the system for the case to be considered. Continuing at paragraph 29, the appellant in Sarson pled guilty to murder and so did not appeal. 11 months later, the constructive murder provisions were held to be unconstitutional. The appellant's application for permission to appeal late was dismissed without recorded reasons. Queen and Sarson, 1992, page 7 to 8. His subsequent application for habeas corpus was also unsuccessful. The Supreme Court essentially agreed at paragraph 19 with the reasoning of the trial judge. Having determined that the writ of habeas corpus could not issue in this case, Justice Watt went on to hold that even if the appellant had established a right to habeas corpus, the writ was unavailable owing to concerns with the need for finality in the criminal justice process. In Justice Watt's opinion, it would be quite intolerable where findings forever to remain impeachable upon the basis of any or all authorities decided thereafter. Justice Watt further stated that the need for finality is generally served adequately by the application of the res judicata principle. A matter, once finally determined, cannot be relitigated. Based on this court's decision in Queen and Wigman and the Queen and Thomas, Justice Watt concluded that the conviction of the appellant was res judicata and unimpeachable by collateral attack. As a result, Justice Watt held that the remedy sought by the appellant was unavailable. Wigman, Thomas, and Sarson are authorities that raise a significant obstacle for applicants like Mr. Cantor. In the Queen and Johnson 2003 SCC 46, the Supreme Court of Canada confirmed a British Columbia Court of Appeal decision holding that the long-term offender provisions must be considered before imposing a dangerous offender designation. A review was undertaken of all files in which the offender may have been sentenced under a mistaken view of the law. The appellant in the Queen in R&G MA 2002 BCCA had been declared a dangerous offender in 1998 before the law was clarified. His application for leave to appeal late was granted because it appeared that he might have valid grounds for appeal and the interest of justice warranted allowing the appeal. The decision in GMA relied on the residual discretion of the court to allow a late appeal when the interest of justice so required. The court does not appear to have been referred to Sarson, but it distinguished Thomas on the basis that it only applied when the appellant had been convicted of an offense subsequently found to be unconstitutional. That was a category of case where the law as it then existed was correctly applied. The court at paragraph 22 distinguished the situation in GMA as being one where the wrong law had been applied. These applications, however, arise in a very different context. These applicants do not seek a new trial based on a fundamental change in law flowing from the application of the charter. They ask only to be allowed to appeal against one aspect of the sentence imposed upon them and to be permitted to do so on the ground that recent decisions of this court have revealed that the failure to consider whether they were long-term offenders was based on an erroneous view of the code section as it existed at the time of sentencing and as it remains. While there may have been valid reasons to allow a late appeal in GMA, this is not a sound basis on which to distinguish Thomas. The principle of res judicata means nothing if it only applies when it is subsequently determined that the previous decision was right, and not if it can be demonstrated that it was wrong. Enin and Northern Heights, and some other cases are referred to. It defeats the whole principle of finality if the merits of the previous decision are always open to re-examination. So in respect to your first question, going back to the questions, does the principle of finality apply? We say yes, sir.
And are there any exceptions to it?
Excuse me, sir?
Are there any exceptions to it?
There are exceptions to it, sir, but it doesn't apply in the circumstances of this case. Because when one strips away the emotive and colorful language in the submissions of my learned friends, it boils down really to one point. There has been a change in the law in regards to the number of challenges the Crown had, not challenges, the number of standbys the Crown had in relation to the applicants or the appellants' peremptory right of 3 challenges, and accordingly, they are seeking the conviction to be overturned on that basis. I will expand a bit more on that. Mr. Pettingill spent a lot of time on the Jamaica Trot circumstances, and he made reference to a teacher who was present. But the teacher would not necessarily fall under what is the law referred to as a reasonable observer. Because my understanding of the reasonable observer is one who is pretty much disinterested and is aware of the relevant circumstances, what their view would have been. As it was discovered, the teacher in question, who is actually a close high school friend of counsel. That's one. 2, he entered the courtroom after the first person was challenged. Counsel submitted that there were 10 challenges, of which they were all of African Caribbean descent, when that is not so. The first person who was challenged was a white Bermudian, and he was challenged he was stood by, or the standby had nothing to do with his race or his age.
He was excused.
And the other persons who were standby, there were bases for which they were stood by.
Mr. Mahoney,
Yes, sir?
can you help me? I mean, you referred to the teacher, but the Chief Justice dealt with this matter, for instance, of the 10 jurors being stood by without reference to the teacher's evidence, looking at paragraph 4 onwards.
Yes, sir. But in regards, the initial application was that in regards to equality of arms, and there was also an allegation of bias in respect of race and so on. And when, at the time of the hearing, my learned friend actually withdrew the second part, stating that the prosecutor did nothing wrong, and the focus was really on the equality of arms. So I was a bit surprised that my learned friend was going to town pretty much in his submissions at this stage, when that particular aspect of it was never really pursued at the hearing.
And
So, Mr. Mahoney, as a matter of principle, are you implicitly accepting that if the circumstances were such that there could have been, or that there might have been, an appearance of bias or potential bias, then those circumstances would meet the test for reopening?
No, sir. I will have to, there's the issue of bias that is being dealt with when I deal with the ground of appeal for LeVeck Roberts. I think the fresh evidence application. there are some authorities that I would have to invite the court to consider as well, sir.
So you say if there was an appearance of bias, that would not justify reopening the case.
Well,
But wait a minute, you said that there are exceptions to the principle of finality. I'm not quite sure what exceptions you recognize.
well, sir, in regards to the appearance of bias, I think the decision was along the line that there doesn't have to need to be any actual bias proven, but
No.
the appearance is, excuse me?
Well, yes, that's the case. It does not.
That is
Right.
the test.
And the appearance of bias was based on the question of the numbers, the inequality of arms. So
Yes.
right. So that is what caused a change in the law, that ruling of the Lord Chief Justice. And then there's a subsequent amendment to the statute by the legislation.
Oh.
We're back to the old question of finality of judgment. Does it apply retroactive to the cases before this court?
There's a breach.
That is the whole point. Because if we're going to go back now to look at the appearance of bias, in effect, we are seeking to apply the decision of the Lord Chief Justice and the amendment in the statute retroactive to all the cases.
What?
Prior to. Could my learned friend mute, please? Or if they wish to raise an objection, please do so.
Oh, I'm so sorry.
Apologies.
Apologies.
Thank you. Yes. So in effect, this is what we are discussing here. Does the mere fact that the numbers, or there was the inequality of arms in respect of the number of standbys in relation to the defendant's right to have 3 peremptory challenge, does it apply retroactive? And that's the reason why I've taken the time to go through all these authorities to remind the court of the principle of finality, that a change in the law does not operate retroactively. It affects the parties before the court that brought the matter there, but it does not go beyond that.
If that is right, then what are the circumstances in which you say it might go beyond it?
I gave an example yesterday in which, for example, in regards to sentence, where there was a change in the law in regards to sentence here in Bermuda, and under the circumstances, cases were allowed to be reopened to amend their sentence only. When it comes from my understanding of the authorities in respect of conviction, and I think Cantor dealt with that issue to a certain extent, when it comes to conviction, there is the general principle of finality in the proceedings. If, for example, outside, separate and apart from the, let's say, separate and apart from the numbers, the standby, and so on, there was fresh evidence to show that, and this is just an example, an hypothetical example. Let's say there was fresh evidence to show that a witness had lied. Subsequently discovered that the witness had lied. The witness was nowhere near there. Evidence disclosed that the person who said they were at location A was actually 4,000 miles away. Those are exceptional circumstances in which the...
That's got nothing to do with the jury selection process. And I think what we're trying to discern is what you say would be exceptional circumstances for reopening on the basis of the selection process, if any.
I have not come across any authority that would suggest that it can be reopened. I have indicated to the court the case of English, which I think is a case on point, in which after the decision of Bain, upon which Tyson relied on, upon which Jamaica Trott relied on, the case of English sought to rely on the change in the law, sought to rely on the inequality of arms argument to reopen his appeal, and he didn't go anywhere. He was unsuccessful in that attempt. And there are many other cases in the Canadian law reports subsequent to Bain, which show attempts made by other persons to apply Bain retroactively, and they were unsuccessful. So I have not come across any authority, and I think my learned friend, if they had come across any, they'll be more than happy to share it with the court and with myself. I have not seen any personally.
Yes. The difficulty is that the basic principle is that a change in the law doesn't operate retroactively. But there are, at least in some cases, exceptions to that principle. You've indicated it may apply if there's a change in the law relating to sentence, or if the witness was discovered to be fraudulent, or something of that kind. But that begs the question, as I started the morning with, as to what is the test for when there should be an exception. And I quite follow that you rely upon English, and in that case, there's a reference to Bain. And in the decision in English, the court said, in Bain, the Supreme Court of Canada held that the process of jury selection was inconsistent with the Charter. And then it went on to say the jury selection process was not challenged by defense counsel at trial. The Bain decision was rendered after the trial took place. At the time of trial, the jury selection procedure had not been declared invalid. And inasmuch as 4 judges on a panel of 7 in the Supreme Court in Bain suspended the declaration of invalidity for 6 months, the Bain decision cannot be applied retroactively. In this case, to upset the decision at trial. It's not entirely clear what is the principle that the court is applying. I mean, if it's simply on the basis that in Bain the Supreme Court suspended the declaration, well, in the present case, Chief Justice Hagan suspended the declaration, didn't he?
But the change in the law occurred many years after these convictions and the appeals were closed. Rangman went all the way to the Privy Council, and his matters were closed.
I know that, but I'm still grappling with, I mean, you say a change in the jury selection process is not something which justifies departing from the finality principle. And I follow that, but I'm a little unhappy about working out what the exception to the finality principle is. Well, never mind. I've told you my problems.
Well, I can only draw the court's attention to the the Stephen Grant case where
Yeah.
some exceptions were pointed out. After going through the authorities, some Australian and English authorities.
Right.
And I think Cantor actually indicated a possible exception that's dealing with sentence as opposed to conviction. Not to overturn the sentence, but to adjust the sentence.
That itself seems slightly odd. If the law changes so that something different should have been done when you were sentenced, you can get a change in your sentence. But if the law changes so as to show that the method of selection of the jury was apparently biased, you can't set aside your conviction. One might think that if you could set aside the sentence, a fortiori, you ought to be able to set aside a conviction.
Well, in regards to the sentence, I think there are two different approaches. You will notice that in Stephen Grant was unsuccessful in having his sentence adjusted. And in the Canadian jurisprudence, in Cantor, they cited this case of GMA, where apparently that was done.
Yes.
So it's not across the board. And I think it was to tinker with the sentence, not to replace it completely.
Right.
So that's in regards to the first question. And
Right.
Mr. Pettingill made reference to this case of AIC Limited and Federal Airports of Nigeria. Circumstances of that case doesn't assist this court. That was a case in which the judge made an order and few days after sought to change the order. That was not a case of change in law.
Right.
So that case is distinguishable.
Mm-hmm.
And in fact, the relevant principles can be found in paragraphs 50, 60, 67, and 74. I will not take the court there, but I've identified those to show that that case doesn't really assist us in this.
Sorry, could you give me those paragraph numbers again?
Okay, paragraphs 50,
Yep.
60,
Yep.
67,
Yep.
and 74.
Thank you.
You're welcome, sir. In respect of Mr. Lynch's submissions, he mentioned deliberate rigging by the Crown when none of these were actually alleged in his submissions. And made reference to 4 young Black Bermudians being stood by. None of those were ever alleged in his submissions. And I humbly submit that these were just to supplement the situation where I think counsel are aware that the real crux of their case is the mere fact that there was a change in the law and the Crown stood by X amount over 3. And in fact, I think only the appellant, Kyrie Smith-Williams, would actually be in the situation of over 3. Because in respect of Brandman, I think we look at it next week when we go through the actual standbys and so on. It was really 3. We stood down 6 or so, but when you remove those persons with cause who were excused by the judge, it really came down to 3.
Well, we'll have to look at that next week.
Yes, we'll look at that next week. And when it came to LeVeck Roberts, it was 2. And I've addressed you already on that.
Yes, well, that's conceded.
So moving on to section 5. Honest true construction is the effect of section 5 of the criminal code. It's my humble submission that section 5 is really a succinct statement of the principle of finality. That by itself alone, the mere change in the law by itself alone is not sufficient to overturn previous convictions. And I think in that respect, Ms. Greening is adhering with our view on that point. If honest, number 3, if honest true construction, section 5 precludes reliance by the accused in such a case, is that inconsistent with the accused's constitutional rights? We say no. Ms. Greening was seeking to rely on the case of Ferguson, but it's our submission that Ferguson doesn't really assist her argument. One would recall that in Ferguson, it was a case from Trinidad and Tobago, involved certain appellants. They had a matter pending in the court when there was a change in the law, which would have provided them with a defense. The law was subsequently changed back to what it was before. And it was they were contending that they were targeted. And the Privy Council in those circumstances held that they were not a targeted group. In the case before this court, we submit that these appellants are not targeted. It's general principle, common law, succinctly stated in statute, that the mere change in the law by itself is not sufficient to allow a reopening of a case and for convictions properly and fairly obtained by the application of the law as it stood back then. Those cases should not be allowed to be overturned on that basis only. Four, was section 5, if otherwise effective, to preclude a challenge on the grounds of the relevant disparity, a breach of the separation of powers because it was a retrospective abrogation of rights directed specifically against defendants in particular criminal proceedings? We say no. I did indicate yesterday that there was a thing, we are awaiting the Canadian decision of the Supreme Court of Canada in the case of Trohan. The Court of Appeal decision I will make reference to in respect of other points raised in this appeal. But the matter went to the Supreme Court of Canada. That's a case that dealt with the abolition of peremptory rights by the defendant and the Crown. And the
abolition of what rights? Of what rights?
Peremptory rights to challenge jurors, the jury selection process.
Will you repeat the name of the case, please?
It's Trohan. It's the Court of Appeal decision is at page 618, but the matter went on appeal to the Supreme Court of Canada.
Oh, yes.
And in just a short sentence,
I'm so sorry. You said it dealt with the abolition of what?
the peremptory right.
Oh, peremptory.
Peremptory, yes.
What I heard was parental.
Oh, no, sir. I'm sorry.
Yes. No, that's okay.
So, Mr. Mahoney, the Supreme Court result is not available, neither are the reasons.
Excuse me, sir?
The result is not available. It's not just the reasons we're waiting for.
No, the result is available, but the reasoning is what we're.
And the result was what?
It was held to be constitutional. It's just a paragraph.
Right, but
the reasoning is unavailable.
no. But did it set aside the Court of Appeal?
No, what had happened is
It upheld the Court of Appeal.
the Court of Appeal had ordered a retrial,
Yes.
and the Crown appealed to the Supreme Court, and they have appellants in the Court of Appeal cross appeal, and it was held that what had happened is that the law that had amended the abolished peremptory rights
Yes.
came into effect the very day that this particular case was started. The appellant made an application for.
Now I'm just looking for
Yes.
what the Supreme Court did to the judgment of the Court of Appeal for Ontario.
Oh, the Supreme Court pretty much upheld much of the points raised by the Ontario Court. But what it did, it said that the law, since the law was procedural, the argument was that cases that were pending the trial. So this matter started on the day when the act came into force. They're saying that cases that were in the system before should be excluded from the operation of the new act. The Supreme Court of Canada was saying that no, it is a procedural change, and therefore it applied to all cases, whether the case was in the system before the day of operation or after. It applied to all cases, and accordingly, they overturned the Court of Appeal's decision in ordering a retrial and ordered that the appellant in the Court of Appeal case should be taken back into custody.
Right.
I'm so sorry, I'm getting hopelessly lost. The trial started when the section abolishing peremptory challenge came into force.
Yes, sir.
You say the argument was that the abolition should not apply to the pending case. Is that the Crown's argument?
No, it was the appellant's argument that it was unconstitutional and it should not have applied to his case because his case was in the system and he had a legitimate expectation to challenge the jurors, exercise his peremptory rights to challenge the jurors leading up to this trial. So,
this is the peremptory challenge by the defense, is it?
The defense and the Crown.
Oh, I see.
The law abolished the right for the Crown and the
right. So the appellant said,
yes,
I'm entitled, because I'm in the system, I'm entitled to my peremptory challenge.
Yes, sir.
Right.
And that the section is unconstitutional.
Oh, I see. And the section abolishing the challenge was unconstitutional.
That is so.
Right. And what did the first instance court decide? Or what did the Court of Appeal decide?
The decision.
At page 686 of the bundle.
They allowed the appeal, set aside the conviction, and ordered a new trial.
Yes, I see.
And the Crown appealed.
Yes, I follow. Yeah.
The appellant cross appealed. And in the decision was that the section was constitutional.
Right.
It was procedural, and therefore it applied to all cases in the system, whether they predated the section or they came after. But the decision is just a paragraph.
Right. Have we got the paragraph?
No, but I could send it to Mr. Coelho.
That would help. That would help.
Yes, sir.
This is of the Court of Appeals decision we are talking about.
No, it's in the Supreme Court of Canada. It's
Oh, first instance. I see.
No, not first instance. It's the Supreme Court of Canada, federal court.
Right, right. Mhm.
I will send it to Mr. Coelho during the break. Actually, I think we have passed Mr. Coelho's time now.
Oh, have we? Well, perhaps we better. Have we?
No.
Half-
The time has been extended back, so we're good.
Okay.
I'm so sorry. I don't understand what you mean by that.
It's now 1:30 instead of 12,
I see.
so we have good time.
Okay. Are you happy to keep going? Mr.
Yes, sir.
Chairman?
I will send it. I will just read and then I will forward it to you. Just one paragraph. The Chief Justice, the majority of the court is of the view that the statutory change is constitutional and purely procedural, and therefore has retrospective application. Accordingly, the appeal is allowed, the cross appeal is dismissed, and the conviction is restored. Reasons to follow, which that's all it's online. But moving forward, question 5, if the procedure under the amended section was potentially contrary to the appellant's constitutional rights, what is the test in determining whether what happened was in fact contrary to those rights? Again, my answer is wrapped up with the first answer. Back to the question of principle of finality. As to this, do we have to ask how many potential jurors the Crown stood by who were not subsequently either successfully challenged for cause or to excuse under the Juries Act or otherwise by the court, since if either of those events happened, the effect would be that the reason why they were not on the jury was not because of the Crown's exercise of its right of standby, but because they were in fact excluded from the panel for one or other of those reasons. We agree with that. The exclusion for cause or under the Juries Act or otherwise by the judge would mean that the initial standby was in event academic. If they had not been stood by, they would not have got on the panel anyway. We agree with that paragraph. B, what is the position in relation to a juror who was stood by the Crown, but who would or could have been removed for cause or excused from sitting under the Juries Act, Section 15? We submit that the position would be the same as the previous one above. C, what is the position?
Wait, just pause a moment.
Yes, sir.
This is somebody who is stood by.
Yes, sir.
And the Crown, you never get round to the position where any question is raised as to whether he or she should be removed for cause or excused.
Yes, sir.
Why should such a person be treated in the same way as somebody in relation to whom a decision to remove for cause or excuse has been made?
Well, I think there was an example that was given of the lady. Well, there are actually two ladies. In this Smith-Williams case, there was a lady, Miss Simons, She is the HR manager for the Attorney General's chambers.
Wasn't that Coupador?
Excuse me? No, Coupador was another person. Coupador actually works in the Department of Human Resources, but she was assigned responsibility for the DPP's office.
Right.
And some of us have had interactions with her. So in those two instances, even if we had come around to it, or if she was asked, she would have been excused for cause.
So, sorry, can we, this is in Smith Williams, is it?
Smith Williams, sir. Yes, sir.
And Simons, is this Crystal Simons?
No, I'm Linda Simons, I think is her name.
Sorry?
Linda Simons. Yes, Linda Simons, second page, number 35, standby number 12.
Oh, right.
And just as an example, she works in the AG chambers, and she was on secondment to the legal aid office as office manager. And she has in the past assisted us assisted us in the office manager's duties for this department. So using her as an example, there is no way she would have been allowed to be on the panel.
Right.
So
we've got to proceed on the basis that she would have been excused, although nobody actually addressed their minds to it.
That is so, sir. Because the question is, in fact, could she have properly sat on the panel?
So is this an acceptance that there is, in principle, an inquiry of this kind to be had?
Yes, sir, but as I indicated, the practice has been that in respect of, for expediency's sake, normally we have a large number of people in the courts, and
that's a different thing. The reason for it is a different thing. I'm just trying to understand whether you accept that despite your arguments on the finality principle, that in a given case, in any of these appeals, that there's an inquiry of this kind to be embarked upon.
I'm not accepting that, sir, because if we're going to be doing that, we'll pretty much be going beyond the principle of the finality principle, because there is a change in the law as to on the inequality basis, the inequality principle. And if we're going to be going behind the numbers of each case to determine whether or not we are over the 3 or within the 3, we are pretty much going behind the principle of finality. In effect, that's where we're going.
Right.
I would go to D. Well, I'm not sure if I think C. What is the position in relation to a juror who stood by first time round by the Crown and second time by the judge, I guess, excused by the judge? The situation would be the same as in A and B.
Well, they are to be treated as not stood by the Crown. Is that what you're saying?
Yes, sir. D, what is the position in relation to alternates, particularly if no alternate replace an impaneled jury? Our submission that this would essentially be academic, since none of the the jurors were replaced.
Well, in any of the cases?
Yes, sir. No, none of them were replaced.
Right.
If there has been a relevant discrepancy, is the court bound to set the conviction aside? We say no. And again, we're back to the finality principle and the basis that a conviction should not be overturned on the reason only that there was a change in law. If not, what is the test? Is it the one laid down pursuant to Section 21 of the Court of Appeal Act 1964? We said the principle of finality applies. If that is the only basis, that there's a disparity in the numbers. If there is something more apart from that, then the principle as set out in Section 21, whether there was a miscarriage of justice, then the court will move on to that provision in regards to any other issues to be decided independent of the mere change of the law ground of appeal. However, if the court is not in agreement with me on any of my submissions and the authorities, and the court is minded to overturn the conviction, should there be a retrial? It is in the public interest that a retrial is ordered. This case, the implication is it affects every single person who have been tried by a jury in this jurisdiction. At the point of seeking leave to appeal, I recall receiving an email from Mr. Pettingill indicating that there are about 49 to 50 plus prospective clients in line waiting to make their application to reopen their cases. I stand to be corrected, but Mr. Coelho supposed to have that email. And therefore we would have mayhem in the society.
Beg your pardon? We would
Mayhem.
mayhem.
Yes, sir. If all of a sudden, all the properly cases that were completed, and all of a sudden everybody up at Westgate are allowed to have their cases reopened, conviction quashed. And of course, if the Crown was to seek to do likewise, saying, okay, since the trial was a nullity on the inequality principle, are we allowed next to bring back people who are acquitted by those jurors?
Sorry, didn't hear that.
No, I said, as per, I think it was Canto, and I think it was Gov Arbor, that the Irish case. It also opened the possibility that the Crown may argue. So therefore, what about those persons who had their trial under what is now declared as unconstitutional?
Frankly, I don't see how that could arise, because the disparity in question was one that was unconstitutionally in favor of the Crown.
Very well, but it's still going to lead to mayhem. If everybody,
That's your first point.
Yes, sir. Still going to have question of public policy. So the case really starts and ends in our submissions on the whole question of the finality principle. At this
But
juncture,
in relation to
yes, sir.
sorry, Mr. Mahoney, in relation to those 50 waiting in line, it could be that a large number of them, there were 3 or less standbys. And it could be that there were 20 or 10 or 20. In each case, there would really have to be an examination of what was the true position, wouldn't there?
Yes, sir. But we're right back to the very point whereby we're looking at the numbers, and the mere fact that the number was over 3 by itself will be seen as a basis upon which a conviction should be quashed and the case reopened. And that's the whole point of the finality principle. A mere change in the law by itself is not sufficient to quash a conviction which at the time was obtained.
Made that point.
Where else, sir? Those are my submissions for now on this point. Not sure if I could assist the court.
Well, could you just, yes, you can, I think. Can we look at the saving provision in the Amendment Act?
Yes, sir.
You say that all that does is to set out the common law, namely that changes in the law are not to be treated as retrospective. However, there are some circumstances in which the court will treat a change in the law as having retrospective effect, because it will permit an appeal way out of time and may set aside the conviction if it comes to the conclusion that the appellant has suffered substantial injustice because the law was not correctly applied. And what is said is that in the present case, the law that was in fact applied was unconstitutional, and it is said that meant that there was an appearance of an unfair trial or a reasonable appearance of bias, and therefore the decision of the jury is invalid. Now, I quite follow that you say that that's not how we should approach matters, and the mere fact that there has been a change, well, the mere fact that the provision has been held to be unconstitutional shouldn't affect past cases. But if the position was that the decision that the previous procedure was unconstitutional does affect, or should be allowed to affect, past cases, if, on that hypothesis, we get into this problem, don't we? Because if one looks at 5.1, the method of the challenge of jurors under section 519, before the coming into operation of this act, is not invalidated by reason only of the amendment. But if the position is that one is entitled to look at the position that the appellant would have been in if a non-constitutional procedure had not been followed, if one is entitled to do that, the method of challenge would not be invalidated by reason only of the amendment to section 519. It would be invalidated because the method of challenge was unconstitutional.
Sir?
Sorry?
No, I wasn't sure if you're finished.
Yeah, no, I'm finished. That's what's being said against you.
Oh, well, sir, even if And we are not saying that it is unconstitutional. Even if this court declared Section 5 unconstitutional, we are
Right.
with the default position. What is the default position? The common law principle of finality. As I've indicated before, I think between all of us, we have searched far and wide, and we are yet to find a case in which a change in the law, even if the constitutional provision is declared void ab initio, wherein it allows the reopening of previous cases.
And Mr. Mahoney, might
Yes,
not,
sir.
might not one interpretation of subsection 5.1 be that the amending law itself ought not to regard as having retrospective effect, without reflecting upon the constitutionality of the position that appertained before?
I agree with you. That's the position, that it doesn't operate retrospectively.
Yeah.
And that's why I said it is essentially
And
just.
such an interpretation wouldn't offend the Constitution, would it?
Sorry, I didn't get the first.
And such an interpretation would not appear to offend the Constitution.
My submission is it doesn't.
Well, that would work. So 5.1 is interpreted to mean the provision in this act changing the method of challenge of jurors does not operate retrospectively.
Yes, sir.
Well, that's fine. The difficulty then comes in relation to 5.2, because if you're right that the change of the law constituted by the alteration of the procedure that doesn't operate retrospectively, and that there is no exception to the no retrospectivity principle, which entitles the court to look at previous convictions passed following an unconstitutional procedure. If you're right about that, no problem arises. But if you're wrong about that, and the court is entitled, for instance, to say that this is one of these cases where the court should, in effect, apply the change retrospectively, because what has happened is that the appellant has been convicted in circumstances where there was a real appearance of bias on the part of the jury. If you say that, 5.2 doesn't help you, because it says, accordingly, no conviction shall be quashed solely on the ground that it resulted from a trial in which the Crown stood by more potential jurors than a defendant or defendants together were able to challenge. And on the hypothesis that I'm putting to you, the conviction wouldn't fall to be quashed solely on the ground that it resulted from such a trial. Well, it might be, but the provision that it couldn't be quashed on that ground would itself be unconstitutional. You follow what I'm saying?
Yes, but I respectfully disagree, because this case is this section, the subsection 2.
Yeah.
Actually, English is the case of subsection 2 in action. The Canadian case of English.
Mm. Right. Right. Okay. Thank you.
You're welcome, sir.
Well, I wonder whether that might be a convenient time to adjourn. It's a quarter of an hour earlier than.
Oh, my lord, yesterday you had asked a question just quickly in regards to LeVeck Roberts, the two
Oh,
jurors.
yes.
Yes, you are correct. The two that you identified did not actually sit on the panel.
Sorry.
And look at the affidavit of Miss Allboy in regards to the jury, the names of the jurors on the panel for Roberts. Those were the two names that were not included.
I'm so sorry. Which two names are we talking about?
The two names in Roberts were
There were Greaves and Mello.
yes, sir.
Yeah. Right. So Greaves and Mello are the two who were stood by and not either removed for cause or excused.
Yes, sir.
Thank you. Okay. Right.
My Lord President, as I had indicated, my appointment is not until 1:30 now. I'm not sure if you were adjourning for the day or if you wanted to hear
No, I'm
the
not adjourning
appellant's
for the day.
reply. Okay.
Um,
Well, I'm only
But-
saying that because if you wanted to, you have the time now to hear the appellants in reply,
mm,
or if you want to take a morning break.
well, wait a minute. How many hours have we had already?
About almost 3 hours.
Almost 3 hours, 2.25. One would normally stop after 3 hours for the luncheon break.
But the problem if we adjourn completely is that we're only going to have half an hour or maybe less before Mr. Coelho has to go. So won't it make sense to have, if we can manage it, a small break now and keep going for as long as we can?
All right. But sorry, if we keep, when do you have to go, Mr. Coelho?
I'm leaving for 1:30.
And when would you be back?
The funeral should only be an hour because of the COVID restrictions.
So when would you be back?
2:30.
And it's now
11:45.
right. Well, why don't we have a 20-minute break now, or half an hour break now,
Mhm.
and resume at 12:30.
12:15.
12:15. Yes. Okay. Resume at 12:15. And then resume again after you've returned from the funeral,
Okay.
which will be at 3:15.
No, 2:30.
No.
30.
2:30. So it'll be 2:30. Okay. So we'll adjourn now until 12:15. We'll sit from 12:15 until it's 1:30 too late.
No, that's fine.
Okay, 12:15 to 1:30, and then we'll resume again at 2:30.
Okay.
Is that all right?
Yes.
And I hope the persons at the prison understand that timing. Can you make sure that they do?
I think there's a prison officer behind the appellants indicating
Right.
that they understand.
Right. Okay. So we will resume at 12:15. We will sit until 1:30. We will then break, and we will sit again at 2:30. Understood?
Thank you.
Thank you all very much.
Are we going to the breakout room?
Yes, we are, please. Oh.
You're on next, you're on unmute. You're unmuted.
Right.
Right, are we? Oh no.
Was she eating?
Oh, where is Trot in the bundle?
Right, I see everyone's here, but we don't have one of the appellants.
Page 142.
Okay, here's Mr. Brangman.
Trot
Wait a minute.
142 of the
Of the,
record.
yeah, no authorities bundle.
You're unmuted.
Oh,
Right. Well, thank you, Mr. Mahoney, for part one.
You're welcome, sir.
Who's going next?
I believe I am, my lord, if that's
Right.
convenient.
Yes, certainly.
Thank you, my lord. My lord, if I could just briefly, and I think I will be brief, address Mr. Mahoney's part one. On a couple of things he said with respect off the cuff, I think I should clarify. So one of those was the comment, my lord, about upwards to an email I apparently sent upwards to 40 or 50 people. Just to set the position straight on that, there were 40 or 50 people that came out of the woodwork after the Trot decision on jury bias and the ruling and the change of law.
What does came out of the woodwork mean in this context, Mr. Pettingill?
I think it means that people raised the issue of their jury selection with myself and Mr. Lynch.
Right.
And we made it clear that it was certainly not automatic. And in a few of those cases, we had the opportunity to look at and dismiss that it, would not be something to be considered. But we anticipated, my lords, that the task would be that after a ruling from your lordships, that there would be an assessment of each case, subject to how the court decided that it needed to be approached. With respect to, I take issue with the fact that, in my view, it's certainly not, as Mr. Mahoney put, all of the cases that had been done before. It may perhaps be a number of, or the majority of cases that he personally dealt with that he's observing. But I would take issue and don't think that it's all of the cases that have gone before. But candidly, I don't know that it matters. There will have to be an assessment, much in the sense of the assessment we're doing here now. So I say that because it doesn't just automatically open the floodgates, as Arbor indicated, which is a very different case on point, to thousands and thousands of appeals, even in Bermuda context. There were 40 or 50 that raised the flag of questioning this initially.
Those are the ones who made inquiry from yourself.
I'm
There
sorry,
may be
Lord?
others.
Yes, my lord.
Those were the people who approached your firm or Mr. Lynch's firm, but there may be others.
My
So
lord,
we can-
there may well be. There may well be. I think I would. Sorry.
I'm just going to say it's like a substantial number in the context of Bermuda.
Yes, my lord. I can't say that. I would say perhaps because I had conduct of the Trot case, it became a bit of a lightning rod for the approach. So wouldn't. It's hard to speculate, but yeah, that's a number anyway. But as I said, the important thing, my lord, is even on a cursory review of some of those cases, they weren't going to fit into the box, and it would require an assessment. The affidavit in support of Trot, that was raised by Mr. Mahoney. I've taken the liberty of sending it to your lordships because it was raised. I think that it does reflect, if it assists, the types of concerns from a reasonable observer, which was a teacher with his students. I should emphasize, my lords, I've never met, I don't think this matters anyway, but I've never met that man before in my life. So Mr. Mahoney said something about him being a high school friend of counsel's. I had no idea who he was. We had to find out his name after approach. So the point is this, that affidavit reflected a person who was not on the panel, which
Yes.
I certainly saw as being important. It was a teacher that was in
The Chief Justice took it as representing reality without actually referring to it.
Yes, my lord, he did. I think in the early paragraphs on the summary of what happened. But if I could also make this point, what occurred in the interim and why it wasn't relied on and pushed was that the Crown gave an indication to me that they intended to amend the law. And so it was important to have a ruling, and the Chief Justice certainly took that point. Your Lordships will see how it went because it was suspended. But we knew full well there wasn't going to be a trial on the issue. And at that point, there was no need, in my respectful view, that's why I took that approach, to get into the extent of that allegation that was set out in that affidavit.
Yeah.
We didn't need to, because it all became, the points with regard to appearance were accepted. But the affidavit is right on point with regard to what the concerns may be of a right-minded person. My lords, if I could just turn briefly, excuse me, to the issue of finality, which is where my learned friend for the Crown seems to peg his entire argument, that it's finality is finality, and not on all of the other issues. But on this finality issue, one has to say this and concede, it has to be an accepted point that finality is an accepted principle of public interest. Res judicata is an accepted principle. That's number one. Number two, and the next steps, as your lordships have raised, is to consider if there are exceptional circumstances that obviate the doctrine of finality. And I would highlight to your lordships, in the Arbor case, which my friend read at length, and I don't intend to do that, but I would like to certainly indicate to your lordships a number of paragraphs that I think are important. My lords, if we just briefly turn to Arbor. It's page 23, my lords.
23.
No, sorry, I'm sorry, page 426. I'm looking at 23, page 426 of the Joint Bundle Authority. The first one. This. Yeah.
It's a different point.
Well, it might be. At paragraph 28,
Yeah.
the Chief Justice comments, and this relates to this case, and this is what distinguishes it. Paragraph 28, my lord, which is, sorry, at page 428 of the record. In the circumstances, oh, sorry.
Yeah, I have it.
My lords, yeah. In the circumstances, while it might be said to be somewhat analogous to the assertion of a claim made on jus tertii, it is nonetheless in the nature of a collateral attack on the status of his conviction for the offense in accordance with law, at least as it then stood. That is to say that he cannot and does not complain of any inherent constitutional injustice or unfairness in the process by which he was convicted.
That's not this case.
And that, of course, is not this case, because it is very much a constitutional issue. And if I could just indicate these references to your lordships, that in each and every ruling in Arbor, their lordships make it quite clear and unequivocal that there are to be considered, or they should be considered, exceptional circumstances. So, my lords, those paragraphs are contained in Arbor at paragraph 179, paragraph 191, paragraphs 264 and 265, paragraph 282, and paragraph 291. So all of their lordships were ad item on the position that one had to consider that there were exceptions to the rule of finality. My lords, we respectfully submit that it's hard in our respectful submission to conceive of a more exceptional circumstance than jury bias or stacking the jury of that type of approach. My Lord President, with regard to that question of the exact test, I would say that each case, of course, will turn on its facts. But we would say that this has to be just such a case. And my lords, if I could just, now if I would refer to, and this is going to be the last case I refer to, but Trott is so important here. If I could refer your lordships to Trott, which is at page 142 of the record. And my lords, if I could ask you to look at paragraph, I'm just going to refer to a number of paragraphs briefly, but the starting point would be at paragraph 21 of the ruling. My lord, his lordship states, in the United Kingdom, whilst the Crown's right of standby still exists, it has been the subject of guidelines issued by the Attorney General since at least 1978. The current version, updated in 2012, notes that in 1988, the defense's right to challenge jurors without cause was abolished. The prosecution's right to do so was, however, retained. This means that the prosecution can object to a potential juror without giving any reason. It is recognized that this is an exceptional power, and so the Attorney General has issued guidelines to the prosecutor on its use. My lords, if I could make this submission. If one accepts that the exercise of that power or that right of the Crown should in fact be exercised in an exceptional way, then any breach or unfair application of that power or any reasonable observation of the perception of bias, in my respectful view, would amount to an exceptional circumstance, because it's breaching a power that should only be exercised in exceptional circumstances. And so I would respectfully submit it could be nothing else but exceptional.
Sorry,
what is raised?
I'm so sorry, I got lost.
Sorry, my lord.
What could be nothing else but exceptional?
If one accepts, my lord, that the use of the power of the standby is exceptional, I would submit that any breach of that power is an exceptional circumstance that warrants obviating the principle of finality.
I think what you mean is that if you accept that the right should be exercised only in exceptional cases, the exercise of the right in non-exceptional cases is objectionable.
Yes.
Is that what you're saying?
I'm like, your lordship said it far better than I did, but yeah, yes, that I embrace that one.
Yeah.
My lords, if I could commend these paragraphs to your lordships, and I do intend to touch on a couple.
Before we move on, though, but isn't that in the context? Isn't that in the context where it is accepted that the continuation of the right would itself not be unconstitutional?
The continuation of the right.
Because it continues in the United Kingdom.
Yeah.
And the guidance that it should only be exercised exceptionally is what applies there.
Yes, my lord. What I'd say to that is that that is obviously it doesn't have the application here, but the point is that it constitutionally, in dealing with fairness and in dealing with the perception or the concern of the perception of bias, it is something that should be exercised exceptionally.
Should have been.
Should have been, yes. Should be, well, will be going forward, and should have been before, certainly. Yeah, should have been before and has not been always in every case. And respectfully, we say that this appeal speaks to that in this instance. My lords, if I could commend your lordships to paragraph 23 of Trott. I'm sticking entirely with Trott now, and I just have one other matter to raise. His Lordship said, my lords, the guidelines provide that although the law has long recognized the right of the Crown to exclude a member of the jury panel from sitting as a juror, the exercise of the right to request a standby, or if necessarily by challenge of cause, it has become customary for those instructed to prosecute on behalf of the Crown to assert the right only sparingly and in exceptional circumstances. It is generally accepted that the prosecution should not use the right in order to influence the overall composition of the jury with a view to tactical advantage. And of course, what the submissions and the affidavit and the applications in these cases speak to is just that there is at the very least a perception of a approach of the composition of the jury being made with a tactical advantage. I used the term fashioning yesterday, that it's fashioning in a certain way. I mean, and that was something that's extremely pellucid in the Trott affidavit that I've shared with your lordships. That's a very distinct and clear example of that. But nonetheless, it's the same, certainly in the case of Brangman. With regard to, and I will come to that next week, but I went through it in relation to leave about how it was, fashioned by, influenced by the prosecutions. It was the prosecution all along that instigated the standbys, and in most instances, in the majority of instances, made the standby occur.
That wasn't borne out by what Mr. Mahoney told us yesterday in regard to the racial composition of the juries.
This morning. Sorry?
He did it yesterday.
No, yesterday.
You mean in relation to the Trott case, my lord, or generally?
No, in relation to these three cases,
Yes.
he gave us the numbers for the racial composition of the juries.
Yes. Well, I never, my lord, I never hung the hat on the fact of the racial composition, and indeed that isn't necessarily something that one could take issue with unless you could establish that it's appeared to be as.
Well, the Chief Justice was clearly influenced by it in Trott.
Yes, because with respect. Sorry, my lord.
I was going to say it's the numbers speak for themselves.
Well, they do, my lord, but with respect, that's why the affidavit is important. Then that's why I've sent it to your lordships. Because
we can take that from Trott.
Right.
The point I'm making is that yesterday Mr. Mahoney told us that, for instance, in Brangman, 3/4 of the jury were black, 3 white. In Smith Williams, it was 6 and 6, with the two alternates being black. So not quite in the same ballpark.
Well, no, it is, my lord, but I agree with that, not on a race issue. But let me say this, because this is the Trott affidavit does speak to this, because one of the things that's raised in the Stubble affidavit in Trott is that it appears to be not just people of Afro-Caribbean descent, but also people of a certain age that were vetted. So age and gender. They were black males under the age of 35. And so there's a whole ratio of perhaps tactical approaches that could be taken, because frankly, my lord, you could end up with, and I've seen this, I saw it recently in a case where the majority of the panel, as it happened to be, were mostly white. And in other cases, you may see it where there are younger people or older people. And what the question then becomes is, or what it shouldn't be, is looking at that panel, is there a way to fashion it so that it's favorable to the Crown? So leaving aside the white-black issue, it might be, well, you take older conservative blacks, perhaps, or you'd avoid young black males under the age of 35 because they might be more sympathetic to the young black male in the blocks, or you might take a young white male for the same reason. So there's the standby doesn't just relate to that racial issue. It was pretty obvious. Well, it was of concern by the reasonable observer in Trott that was a concern, because it would appear to be like to him and his students, he says. So it could be a host of reasons. That's not mainly the issue. It's is there a fashioning going on for whatever reasons? And it may also be, let me just make this point, as in Trott, Mr. Mahoney made a response in an affidavit and set out, as I recall, that there were some valid reasons for some of these standbys. And they may well have been. They could have been that, oh, this young man that was stood by was, a cousin of so-and-so, and he was stood by because they were concerned that, he would be favorable to the defendant. But this is the point, my lords. The reasonable observer didn't know that, and the defendant didn't know that. So if the Crown is holding these cards, really it's at its peril, because the reasonable observer watching it go on doesn't know why the standbys are occurring. And that, of course, impacts on the appearance of justice and raises the issue of bias.
So, Mr. Pettingill, if we might go back to the last sentence of paragraph 23 of Trott.
Yes, my lord.
And we're seeking to find a guiding principle for getting beyond the finality.
Yes.
Principle. Is it that you are saying that we should be looking for whether or not the prosecution used the right in order to influence the overall composition of the jury with a view to a tactical advantage? Is that this sort of examination you say we should be embarked upon?
My lord, I of course, I would say yes, that should not use the right, or it's the appearance of them using that right, of course. As
yes,
the Porter Guild test. Yeah, I do say that, yes. If that is the appearance, that somehow a standby, if the objective appearances of the reasonable observer, that somehow a standby may be being used as a tactical advantage or as a means of fashioning the outcome of the jury. His Lordship Clark this morning raised it about what happens if you pick six, but then they don't come back around. One would then say, well, is that not a fashioning? You managed to remove the six.
No, but the Chief Justice clearly drew a distinction between the 9 out of 10 males of Afro-Caribbean descent, which he referred to, and the sort of person who is mentioned at 24B of the judgment, where a person is manifestly unsuitable and the defense agree that accordingly the exercise by the prosecution of the right to stand by would be appropriate. Well, yes. You would agree that too.
I would agree that. Yeah, I do agree that, my lord. Yes, and I would agree that sensibly can happen, and now sensibly is enshrined in the law, in the Amendment Act number 2. Yeah, is enshrined in there. So yes, there is that position. But if you don't have that, then you're left, with the duff of the appearance that you're fashioning. I mean, that to my view is an example of where, by agreement, yes, it would be very difficult for one to endeavor to argue that there was a standby in those circumstances if you stood there and given a nod or a whisper or an agreement to that.
The problem is that there is likely somewhere between the two extremes, which the Chief Justice doesn't go into because it's not relevant for the purpose of his case.
Yeah, I agree with that, my lord. And there's a plethora of factual scenarios that may exist, and that's why perhaps the guidelines have to be given. But I think it comes back to the exceptionality with regard to the issue, and then the determination on the basis of the facts as to the extent of that raises the concern. But in Trott that wasn't needed, but I do agree. My lords, just pressing on then at 25C of Trott, and this seems to have been embraced. This was later embraced by the Chief Justice. Counsel made the submission: the exercise of standing down 10 potential jurors pursuant to Section 5192 of the Code was in breach of the fundamental principle of equality of arms enshrined in the European Convention for the Protection of Human Rights and Fundamental Freedoms 1950, and which was essential in order to secure a fair hearing under Section 6.1 of the Constitution. My lords, I say again, for the benefit of these proceedings and the application of Brangman, I would respectfully submit that nothing could be more exceptional than that issue of a fundamental principle of equality of arms being raised in any of the cases if it was accepted that that was the appearance that the equality of arms was offended. My lords, at paragraph 27,
Could
in
we
the
just,
discussion-
before we get to 27, could we just look at 25B?
Yes, Lord.
The Chief Justice records your submission. The court is not concerned to determine whether or not there was any motivation by the prosecutor to stack the dock.
deck,
Whether
yes.
stack the deck, sorry, with regard to the makeup of the jury, but whether the selection process involving the exercise of standing down would lead a fair-minded and informed observer to conclude that there was a real possibility that the jury so selected may not be impartial.
Yes.
Leaving aside the abuse.
What you've been submitting recently is that there shouldn't have been an appearance of the use of the right to secure a tactical advantage or as a means of fashioning the jury, for which the expression stacking means much the same. There seems to be a tension between those two propositions.
Tension.
You didn't have to deal with this.
I'm sorry? Yeah. Just, I could take a moment, my lord. Sir.
Yeah.
I don't think you needed to deal with it in short because they'd already decided they weren't going to.
Yeah, that was
because they were going to introduce the legislation.
Yeah.
It's not necessary to explore that.
My lord, I would say with respect, in Trott, it wasn't something I necessarily had to explore because obviously the decision had been made ahead of time that we knew they were going to amend the law in the way that they did. But I would say that it's certainly an exceptional circumstances would be anything that leads a fair-minded and informed observer to conclude that there was a real possibility that the jury was so selected and may not be impartial. It's the risk of that that's key. If on the basis of it, it's looked at and the circumstances indicate that or raise that specter of sacking or a bias or a concern in relation to that, that's enough, I would submit. It has to be. Especially in circumstances if the exceptional power is not being used in a way that appears to be fair-minded. My lords, at paragraph 27, I was turning to 27. Really, my lord, it's a repeat of that the Chief Justice mentioned. 5192 of the code is challenged on two grounds: its operation, the selection of the jury in a criminal trial in terms of allowing the Crown to stand by down unlimited potential jurors would lead a fair-minded and informed observer to conclude that there was a real possibility the jury may be biased, and B, it offends against the equality of arms principle enshrined in section 6.1 of the Bermuda Constitution. It's proposed to consider both of these arguments in turn. His lordship moves on at 28 and states the issue for the court is whether the selection process for a jury in a criminal trial in Bermuda, which effectively grants the Crown 36 standbys, which I think we've agreed, my lord, that could be unlimited standbys depending on the number, while the accused person is allowed only 3 preemptive challenges, infringes upon the accused person's right to be tried by an independent and impartial court established by law as guaranteed by section 6.1 of the Constitution. Again, my lord, I say what's being highlighted here is just how fundamental this is, and that any real specter of this being raised is an exceptional position capable of obviating finality. His lordship goes on at 29, as noted by Stevenson, J. and Bain, the independent and impartiality of the tribunal, which an accused person is tried, is a central feature of our criminal law that has long been recognized. The importance of this right in Bermuda is illustrated by its entrenchment in section 6.1 of the Constitution. The plaintiff argues that the system of selecting jurors contained within section 519 of the code impairs the appearance of impartiality and is therefore unconstitutional. The plaintiff's argument is directed at the disproportionate powers the Crown and the accused person have to remove potential jurors from the selection process. The plaintiff argues that whilst the Crown is allowed to stand up to 36 potential jurors under section 5192 of the code, the accused person does not have this right to stand by jurors, and this asymmetry produces the appearance of partially sufficient to amount to an infringement of section 6.1 of the Constitution. My lords, now, my friend, Mr. Mahoney, goes on a later stage that I'll come to endeavor to, I'll deal with that shortly. But my lords, I commend paragraph 31 to you, which in looking at the law indicates that it was not just suggested there was actual bias, because that was something that was let go in this case, in the case of Trott and in these other cases. The question was whether, in the view of the fair-minded and board observer, there was a real possibility of subconscious bias on the part of lay member or lay members. Subconscious bias is what needs to be considered by this approach. My lords, at paragraph 35, and this...
That's subconscious bias on the part of the, in that case, the members of the Employment Appeal Tribunal.
Yes, yes, my lord.
But I mean, are we talking about subconscious bias of the jurors?
Well, we could be. No, my lord, not in this instance, no.
No, quite.
No, we're not.
No.
Now, more well, perhaps it's a subconscious observation of the reasonable observer, I guess, with what they might be formulating in their minds. My lords, at 35, and my friend Mr. Mahoney seemed to endeavor to make this argument, which I say was rounded on in Tyson and was clearly dealt with by the Chief Justice. At 35, his lordship states, in previous cases, it's been argued that even if there is an appearance of bias on the part of the court, it does not necessarily follow that the accused person did not receive a fair trial. In Tyson, that seemed to be my friend's submission. In Tyson, the Crown suggested that A, it was necessary for the accused person to demonstrate that there was actual bias on the part of the jury, and B, that when the trial was looked at as a whole in relation to overall fairness, the appellant suffered no injustice. His lordship states, I agree with the decision and reasoning of Gonzalez J.A. that the appearance of bias on the part of the jury, and therefore the court, is in itself sufficient to demonstrate a breach of an accused person's fundamental right to a fair hearing by an independent and impartial court, and constitutes a breach of section 6.1 of the Constitution. So with respect, my learned friends attempt to say that one has to look at it in the whole and all the circumstances can't be right, especially, my lords, when we're dealing with a fundamental right. And I would submit that once you have the issue of a breach of a fundamental right, then you get into the box of an exceptional circumstance, because nothing could be more exceptional than that. It goes to the very core of our justice system. And at 39,
so the Canadian cases which decided in effect the contrary are just wrong, are they?
They're just wrong. Sorry, I mean, this is with respect. I mean, this is the Holy Grail. You know, the Crown, the law changed as a result of this. Other than they didn't include in Section 5, as your lordship will see, as I mentioned before, when they went before the Chief Justice and said this is what we intend to do. But the law changed as a result of this. This is the position in Bermuda. This is an analysis of our Constitution, which was not appealed. The Crown folded on it. His lordship delivered this extremely thorough judgment in relation to analysis of the law. And I would say, yes, those the Canadian cases or anywhere else don't have any application, certainly beyond the considerations that have been set out in Trott and the law as it has been changed, leaving aside Section 5.
Mr. Pettingill, even if we accept that sentence from paragraph 35 as correct statement of the law, for present purposes, does it not beg the question whether or not there was an appearance of bias on the part of any of the jurors in this case? And how does one answer that question?
What would you say? Analyze that? Would you?
You don't have to.
Are you saying merely on the basis that, in fact, the Crown had stood by more than the defense did?
Yes.
Yes.
Or the existence of the state of the law at that time?
Yeah.
But either of those factors would be sufficient.
Yes, my lord. If they stood by more, and one can't establish that it was for valid reason or excused by the judge, it comes down to the initial step is the appearance. So yes, that would be in my respectful submission. The answer to that is
So
yes.
it depends. It comes back to why they stood down more. What was their reason? Whether there was an attempt to stack the jury or not. Is that what ultimately you're saying?
That does not matter with respect. That doesn't
You're
matter.
saying once they stood down more, that's sufficient.
Yes.
I say that, yes. Yeah. Once they stood down more, you've crossed the Rubicon. And it doesn't matter. And Justice Bell raised that question before on the leave application. I mentioned that yesterday. It could be 4, it could be 40. Once there's an imbalance, there's a risk of bias. Once you go past the threshold, you're there. What's the point in having a line in the sand if you can just jump across it as you please, or say, I'm going to draw another line in the sand? It matters not.
But of course, the thing is that at the time, that wasn't where the line was drawn.
Well, yeah, it's where the line should have been drawn, though, my lord. That's quite right. But when one looks at it, that is where the line was there with respect. What happened was everybody was just running across it, not paying attention to it. And unfortunately, there are these cases where it begs, like, why was it made use of to the extent that it was? That's the question that has to be asked the fair-minded observer and for the court. Why? Why was it necessary? And to His Lordship the President's point, in some of these, we just don't know. If you stand down 6 and they don't come back, you don't know why they stood by. So the appearance is you just managed to remove 6 for unknown reasons, or you managed to remove that one person that I, as the defendant, looked like was going to give me a fair shake, that I believed looked like somebody that would, weigh in the balance, and you removed them. And they got replaced by somebody who glared at me and I don't think it's going to give me a fair shake. How is that fair? You've got more, that was your 4th pick. That was your 4th stand.
Yes, go back to the conversation we had a little earlier. I mean, if there are, in a particular case, 12 standbys, and they're all of young Afro-Caribbean males, and the defendant is the same, that's one thing. If there are 12 standbys and 6 of them are white, of whom 3 are old, 3 are young, and you've got a balance of male and female, ditto for black. So in that sort of case where you can't see any obvious case of jury stacking, does it necessarily follow that the exercise of that number of standbys creates an appearance of bias?
Absolutely. Absolutely, with respect, my lord, because the point is this.
Why?
Thank you. It's not as simple as it being black or white. It's for the reasons I said, it is the concern of, is there a certain tactic that's involved here? And to your lordship's, example there, it could be that one looks at it and makes the assessment on the person of, that is an older person of Afro-Caribbean descent that looks very conservative, that looks very religious, and it's assessed on the basis of, that is a conservative looking person that would be right for this jury trial. It could be in looking at it and assessing it, this is a rape case, and that woman, with respect, that lady looks like she's just steaming up the ears on how the understandable horrors of this are, and I want her on the jury. So it isn't going to be always as obvious, and that's why it can't be, in my respectful submission, the rule as to how it's ascertained can't be be that clear. It has to be once you cross the line. In trot, I think
isn't that in effect an argument that there is a deemed appearance of bias, whatever the circumstances may
yes,
be?
exactly, my lord.
That's what you're saying, isn't it?
It's deemed. It has to be. And with respect, Justice Bell, I don't think that one can get into what the rationale or the reasoning was. It's the fact that it was done. And it may be that those of us that have assessed juries for
Of what was done.
yes, the appearance of what was done. Yes, my lord, sorry, the appearance. And it may be that those of us that have assessed juries for a number of years, and we all do it. I mean, there's people that, you know, I would advise a defendant, I would, you know, challenge that person, either because I would get a feel from experience. I didn't like the look of them. I thought they were overly conservative. I didn't like the way they looked at the defendant. All of these nuances, you know, that's why you'll see in the affidavit, and I don't mean this in a disparaging sense because we all do it in a way, that in the affidavit in Trott, the observation was that the prosecutor was turning around and seemed to be assessing each juror. That was the observation. And I think we all do that as experienced lawyers. The difficulty is that I can only do that assessment for 3. And the Crown can do that assessment for 50 until it gets just that right mix of, you know, young and old and so on and so forth. My lord, there's many nuances that I could go into that I've discussed with colleagues, including the Crown over the years, about who you want on the jury and who you don't. We all walk away saying, oh, the jury looks like a nightmare, or that looks like a good jury for us. And there's reasons for that, because with experience, we assess each individual potentially. And if it's a case of we just are able to stand them by, then the observation, the reasoning is, well, the prosecutor knows why it's in his head. Was he doing it for a reason to get the juror that he wanted? Or did he have information that was valid, that when they came around later, they would have been excused? If we don't know, then it has to be deemed, Justice Smalley, it has to be deemed as such, because you can't go beyond that. You can't know what's in the prosecutor's head. So you have to set the benchmark somewhere, and the benchmark has to be on the number. My lord, can I just wrap trot up then?
Yes.
Just at 39, my lord, in conclusion. His lordship said, in conclusion, it is my view that section 5192 of the code is so heavily weighed in favor of the Crown that a fair-minded and informed observer would conclude that there was a real possibility that a jury selected by the exercise of the Crown's right to stand by was biased in favor of the Crown. It follows that the conclusion necessarily means that the accused person is denied a hearing by an independent and impartial court and is sufficient to establish a breach of section 6.1 of the Constitution. It also allows the provisions of section 5192 of the code can no longer be operative, as they are inconsistent with the fundamental right established by section 6.1 of the Bermuda Constitution. My lords, once you arrive at a position of making a finding that the test is to conclude that there was a real possibility, then you don't need to go further than that. You have to have the line you deemed that crossing that line of having too many standbys without reason. It's deemed that there's a real possibility. It's deemed that there was potentially the appearance of bias in favor of the Crown.
But there is an important phrase that follows, seems to me, where the Chief Justice selected by the exercise of the Crown's right to stand by.
I highlighted those two.
Yeah, so where was that, Malone?
In paragraph 39.
Yeah.
So there's that conditionality. If that is what happened, then there's a real possibility of the appearance of bias.
Yes, Malone. Yeah, precisely.
Doesn't that suggest then that one has to look at what really happened?
No, my lord. I don't think that it necessarily requires that. I think that your lordship, I embrace what your lordship had said earlier. Once you cross that line, it needs to be deemed to be that position. You can't go over the line.
Isn't that the effect of the words selected by the exercise of the Crown's right to stand by?
Well, again, my lord, but we come back to it's that's not a right that one, it has to be exercised exceptionally, and two, it's not a right to be abused. So it has to be read with those concepts in mind, that it's not just a open-ended right, or with respect, it shouldn't be and cannot be an open-ended right. And it wasn't, in my view, it should not have been an open-ended right going back any number of years. And that's the problem, that it was if one uses what is a right and doesn't use it fairly and uses it with the appearance of what is abusive, then it's not a right that's enshrined within the Constitution. It becomes undermined, becomes unfair.
So that proposition is fair enough so far as it goes, but it seems contrary to the notion that there must be deemed to have been an appearance of bias, simply because of the fact that the right to stand by may have been used in a way that resulted in even one more than the defense had the right to challenge.
Well, my lord, I would respect that's fraught with danger, that approach. You can't, it's difficult to go back and have to recreate what the factual basis for that might be. I mean, you have to look at it in the context of, what fairly and properly and constitutionally should have occurred. And it's an exceptional breach if that is flouted. And we say that in all of these cases, it was flouted. That, I come back to the Lordship President's point again. If you're saying 6, it might be just convenient. They don't come around again. And my submission would be in many instances, they don't come around again. You have 6, 10 challenges and they don't come around again. And Trott's a perfect example of that, because Trott is a jury that would have ended up with a very different makeup, but for the 10 challenges. And none of those jurors that were stood by came around again. None. So you had a vet of the 44 people on that panel. The Crown was able to exercise 10 standbys. And that must surely have the appearance that you're fashioning the outcome. That's what the affidavit says in that case. That's what the facts are. That one looks at it and says, wow, that deck appears to have been stacked, or even that deck could have been stacked. Okay. No, one point. There you go. Sorry, my lords, I'm nearly there. 2 more points. You want to deal with? Okay. All right. Okay. If I may, my lords, that's my submission. My learned friend, Mr. Lynch, has 2 points that he had in his submission that I think may be of assistance. Unless your lordship has any further questions for me.
Well, could you help me on this? We've had quite a lot of discussion about what the test of the exception is, and is expressed in different ways. But what is happening in the present case is that you say that a system which has been in force and operative for many years of the jury selection process is, in the light of the decision of the Chief Justice, one that gives rise to a realistic prospect of bias. If you're right, the effect of that may be that a large number of previous cases have the verdict set aside, and those who have been convicted on a proper charge, a proper indictment after a proper summing up, will their convictions will be cancelled, and the whole process will have to start again in circumstances where the Crown may no longer have the evidence that it had first time round. It could be said, and I'm thinking of the formulation in Grant, that there has to be an injustice so fundamental if not reopened, that it far outweighs the public interest in the finality of litigation. And that the fact that there was a realistic prospect under the old system that there might not be that there might be a biased jury is not of itself sufficient to far outweigh the public interest in the finality of litigation.
My lord, one could argue that, but I would come back to the words of the Chief Justice and embrace those. I think it was we may have been quoting that in the consideration, I would say, of the public interest, that the interests of justice to the accused goes to the very, very core of our justice system, that the interest of fairness in a criminal trial goes to the very core of that system. And respectfully, there could be nothing more significant than the issue of bias being raised. If there's one innocent young man up there that is incarcerated as a result of that bias, I mean, that has to be the most significant consideration in my view. I mean, you know, was that Martin Luther King Jr. said that, you know, injustice in one place is injustice in every place. And I appreciate, I do, the consideration of the concern of opening up the box here to a plethora of applications, but that was not the doing of those, you know, accused individuals, and justice is there with her shield to protect that. And in my respectful view, it is truly exceptional if the specter of bias in a criminal trial is raised, and respectfully, that must, in our system, outweigh, and I say this with great respect, the convenience of the fact that these cases will have to be reconsidered. I made that point, my lord, in my submissions, that when it comes to DNA, you know, that opened the box in England, in the UK, and even in Bermuda, where cases in the interest of justice had to be reconsidered because there was a real concern that there'd been an unjust conviction. And that's, you know, by analogy, that's what we're talking about here. It's not quite as scientific or as black and white with respect, as I say. In some instances, it may be. So there has to be that assessment. My lord's heard me say with regard to what Mr. Lynch and myself looked at, we'd indicated that with regard to where perhaps the flag was raised of concern, that starting with the gatekeepers, counsel would have to assess whether there was a valid case for an application to be made. And one that would hope that your lordships, in accepting that, you know, that in these instances that these cases should be dealt with, that there would be guidelines to how they are approached. I mean, we're all ad item on that, and some of the facts that we're dealing with here set out that scenario. Mr. Mahoney seems to think there was only 3 challenges in Brangman, as opposed to the 7 that I'm very, very clear and unequivocal on. That there were, and the way that was conducted, that hearing. So that type of assessment will have to take place before you get to the promised land of all of these cases being set aside. This process in and of itself, my lord, has involved a significant amount of time and filings and evidence. And, you know, in the future with any cases that arise like that, all of those considerations are going to have to be addressed before we get to the door of seeking leave. Because of course it will be for your lordship still in the circumstances to say whether you grant leave in a particular case. So it doesn't, I don't think, my respectful view, and I don't wish to give any evidence, but my respectful view in being involved in this system for a long time, even to Justice Bell, to your point about, you know, it's Bermuda in context, I don't see there being, certainly, you know, hundreds of cases, I don't see there being even dozens that would pass muster with the ability to necessarily be placed before the Court of Appeal. That's my view. If there are, then there are going to be certain hurdles they're going to have to jump over in order to have an established appeal before it could be set aside.
So was there something in, I think you were about to say there's something else in Trott you wanted to draw attention to, or
I think I paraphrased it, my lord. I was just saying in Trott, it's saying that, you know, that this issue, when we talk about public interest, I would say the issue in having a fair and just justice system outweighs anything else. And it's enshrined in the Constitution. I mean, that just must outweigh any convenience. It's not enshrined in the Constitution with regard to finality. Certainly it is with regard to trials being brought in a reasonable time. But what is enshrined is the right to a fair trial. And once you have the concern that that is breached, then that has to be the fundamental consideration in my submission, not an issue of finality.
right? Thank you.
My lords?
Thank you very much. Unless any of my colleagues have a question.
No.
Lords?
Thank you.
Thank you, my lords. I'll just slide to Mr. Lynch.
No, it's probably easier to swap seats. Yeah.
Excuse me.
Join observation. Thank you. Can I first of all say straight away that much of what I would have said has already been covered,
Right.
during either the course of argument or indeed in reply by my learned friend. And as a precursor, once again apologise for having the speaker on when I was interrupting yesterday Mr. Mahoney's submissions, and I apologise once again for doing that. But there are a couple of things I would like to bring the court's attention to, please.
Yes.
And that's this. First of all, in dealing with the cases, and I don't want to rehearse them, much extract from cases have been read into the transcripts here. But I would wish to make this observation. In the case of Sarson, which was a case of habeas corpus, which we brought to the court's attention, the court will understand that in that case, the person's continued detention was pursuant to a conviction under a constitutionally infirm provision. It did not breach the tenets, we would say, of fundamental justice under Section 7 of the Charter. In that country, in Canada, the court relied on what they described as the overwhelming evidence of the appellant's involvement in the death, which could have supported a conviction under a number of other provisions had that been brought before the court at the time. He pleaded guilty to the offence of second-degree murder, and his counsel agreed to a sentence of life imprisonment without parole for 15 years, which was greater than the minimum that might have been imposed. The court noted that the appellant had not entered a plea, and the prosecution may have, had he not entered a plea, the prosecution could have called evidence to support a conviction under a different provision altogether. And so there was a good reason for rejecting their submissions, that he could rely upon this change in the law. And it's clearly distinguishable, we would submit, from our own case, where we say that there is a constitutionally infirm provision is not the offence itself, but the circumstances in which a defendant comes to be tried. And we say, obviously, that is bias. Can I, in dealing, I hope, with some of the observations made by your lordships in argument, our submission, so that it is clear, is that we do not have to demonstrate actual bias. And there is a danger in the exercise that my learned friend, Mr. Mahoney, needs to try and engage the court with, of trying to recreate what happened in court on each occasion. Whether or not 5 or 6 of the people were black or white, whether or not they were old or young, whether they were male or female, in our submission is utterly irrelevant to the issues that your lordships have to determine. Because we cannot recreate the entire panel. I leave aside the question of the evidence to support it as opposed to assertion made by counsel. But the fact remains that we're not in a position, are we, to recreate the entire panel. I simply cannot tell you now. I simply cannot tell you now whether or not the panel included any more young black males, and whether or not there was an exercise being undertaken by whoever it was that was making the challenges or the standbys, applying for the standbys, was making an assessment of who was left and whether that person looked better than what was on the jury at the present time. It's simply not a possible exercise to go through. What your lordships in our submission need to identify is that there was the appearance of bias. And how do we establish the appearance of bias? The appearance of bias is established by virtue of the exercise by the Crown of a greater number of standbys than were available as peremptory challenges by the defence. That's how it's established in our submission. And if I may say so, one of the ways to approach this is that if we are to examine what is the appropriate test to be left for the court to apply, so that all other cases, if there are other cases to come before this court, is to utilize that which has been identified in the United Kingdom as a proper basis upon which to depart from the finality argument. And
I'm so sorry. Would you repeat that? Yes. I distracted myself. I do apologize.
Not at all. I do it myself all the time. And I like to think it's just to do with age. But the position is this, is that in the United Kingdom, once you've accepted, I'll come back a little bit, because I think once you accept that there is this, what might be characterized as a cardinal principle of finality in all hearings, and wherever we go, whether it is, as we know now, the reinterpretation of what might amount to dishonesty, whether a joint enterprise has been redetermined, all of these are cases that have come back, and for years we thought we understood what dishonesty was, and now we're being told there is a slight nuance change to it.
Secondary parasitic liability, that sort of stuff.
Yeah, exactly. All of those things, and they do not give rise to people going back and saying, well, my case was determined on this basis, and can I revisit it now? They don't give rise to it. And that is the necessity of the public policy that applies to the principle of finality. What we say, though, is it simply cannot be used as a trump card for every injustice that might transpire as a result. And if I may, I should like to borrow the words of Mr. Justice Berger in the case of Canto, which is in the supplementary bundle. It's only 5 lines, so can I just read it out? It's a paragraph 53 for your note of that judgment. And it's a dissenting judgment, I accept. He says this: my colleagues place considerable emphasis on the importance of finality. The majority reasons state that while the delivery of justice is a tempting argument, the need for finality is equally compelling. With great respect, finality should not be used as a trump card that presumptively outranks an accused's interest in the fair process. And that's where we are in our submission. We are involved in the fair process of an individual's right to a trial by a jury that is unbiased. In analyzing whether it's biased, that in our submission is recognized by the government here and the legislature determining that it was necessary to change the law because there was on its face an unfairness created by the existence of the law, and it was unconstitutional. So they changed it. And in our submission, where we are is this, is that if you conclude that there was a breach of the defendant's constitutional right to a fair trial, all you're left with is the ability to be able to say, if that is right, what can we do about it? If the raison d'etre for the Court of Appeal is to right wrongs, how can you be emasculated from doing so once you have concluded that there was a breach of a defendant's right to a fair trial? And in our submission, nothing could be more cardinal than a jury being selected by fair process and being able to determine a defendant's guilt or otherwise. In our particular case, as it happens, it was 9-3. One person might have made a difference to whether it be a hung jury or they may have come to a different conclusion. One doesn't know. It's not right to start to analyze the detail of that.
Right, in your case, the verdict was 9-3, was it?
Yes, it was. Yes. But in a sense, that doesn't matter. The
No.
point is that once you've identified that there was a breach, and we submit, as you'll appreciate, that breach is characterized by virtue of the exercise of what the Crown were entitled at that stage to do, but which has now been accepted was a breach of their constitutional rights. Once you've got there, what can you do about it? And there is only one thing to do about it in our submission. There is only one thing, and that's to set aside the conviction. Not every case that comes before your lordships will be able to satisfy the test that you will need to apply. But that test in our submission is probably best illustrated once we've accepted that finality is a principle that needs to be very carefully considered before stepping away from it. One thing the Crown do not depart from is the fact that there are exceptions to that principle. What they were perhaps less able to deal with was whether or not the identification of a potentially biased jury was an exception within that principle. So the exceptions exist.
Mr. Lynch, if I might, how would you articulate what the test should be?
Well, I would submit this, and if you go to paragraph 16 of my submissions, you'll see the original submissions, not the speaking note, the original submissions that we put before the court. I would invite you to go there.
Just a moment.
The leave application.
It's the date. It's the one dated the 15th of February.
Page 26.
It's page 26 of the consolidated bundle. Thank you.
Yeah.
Thank you.
So I'll wait a moment. So the United Kingdom, in grappling with what was a problem that existed by virtue of the fact that the civil courts permitted, in the first instance, under its own rules, revisiting cases and setting out the criteria, it grappled with how do we do that for criminal cases? And it became clear, and I don't need to repeat what I submitted before, or indeed what is contained in our submissions, but the reality was that they recognized that there needed to be some kind of measure by which we can consider each and every application that might be made as an exceptional circumstance to the basic rule that finality trumps all cases. And the exception is so that they can identify that it doesn't, as it were, trump all cases. And here they set out on page 33 of that bundle, please, of your bundle, on page 8 of my submissions, I identify what they've done in the United Kingdom. And what they've done in the United Kingdom is to set out under the criminal procedure rules the approach that the court must take. And it's headed reopening the determination of an appeal, 3615. The application must A, specify the decision which the appellant wants the court to reopen, and B, explain, 1, why it is necessary for the court to reopen that decision in order to avoid real injustice. So pausing there, is a breach of a defendant's constitutional rights, as seemingly must be the case in our scenario, real injustice? must be in our respectful submission. Secondly, how the circumstances are exceptional and make it appropriate to reopen the decision, notwithstanding the rights and interests of other participants and the importance of finality. How do we satisfy the test that it's exceptional? We submit that each and every single case that seeks to fall within this criteria need to set out what they say is exceptional about it. What we say is exceptional about this case is that the jury were biased, or had the appearance, I should say, of bias. That is what makes it exceptional. Would there be a moment's hesitation if it transpired after a trial that the judge in a civil case was said to have been biased and had not disclosed some feature, or it had been discovered that there was a connection between the judge and the outcome of the trial or one of the parties? And I've already made the observation about Pinochet number 2. The reality is that no one would begin to argue, as indeed none of their lordships in that case, all 7 of them, or all 9, I think actually, all 9 of them made clear. It's not a question anymore of whether or not actual bias can be demonstrated, as Mr. Mahoney would like to shift the position to that. Well, you know, there weren't these many people, and those we objected to. And by the way, we had some proper grounds on these anyway. That's not the issue. The issue must be, can you demonstrate that there was bias? And the way in which we demonstrate there was bias is because the Crown used more than they were entitled to. Of course, they were entitled at the time, but what has now been recognized as being a breach of the constitutional right to equality of arms, if nothing else.
Mr. Lynch, I'm sorry, I don't want to cut the thrust of your submissions, but my Lord President, I'm just cognizant of the time now.
2 minutes, please, and then I will have concluded.
Right.
Is that possible, Mr. Coelho? Is that okay?
Yeah.
Thank you.
2 minutes.
Lastly, and the third head is why there is no alternative effective remedy among any potential available, and any delay in making the application. Well, there's been no delay, obviously, but there is no alternative effective remedy than that which your lordships are now currently seized with. Those are my submissions in addition to those which have already...
I may have a question after we resume, but we'll adjourn now and resume hopefully in an hour's time.
Thank you, Lords.
If everyone could just turn off their cameras and mute their mics, but do not leave the call. The justices can go over to the breakout room.
Okay.
Just 1 second. Get this spell on the call.
Ah,
See up here.
Any sign of Mr. Brangman?
There he is.
right. I think, where is Mr. Mahoney? Right.
Yes.
Right. I think we're all assembled. Mr. Lynch, just before we proceed, I have a question. You were specifying the criteria which we ought to adopt in determining whether there was an exception or should be an exception to the principle of finality. And the second, I think, criteria was that the circumstances were exceptional. This may seem a rather silly question, but in fact, the circumstances in which the Crown exercised its right of standby at the time it did weren't exceptional at all. Is that relevant?
No, no, it's not, because of course, as with any enactment that subsequently is either changed by statutory instrument or as passing of any act, or indeed being struck down as being unconstitutional, up until that point, the law is whatever the law is stated to be, and that is the principle of finality, that in action, if you like, that the law is always stated to be what it is. People act in accordance and are expected to act in accordance with that law. It is only subsequently, when it becomes clear that it was either wrong, or has been reinterpreted, or has been changed in some way for other reasons, that one looks back and says, well, whilst of course Mr. Mahoney, in our particular case, exercised what he regarded as his right at the time to stand by a number greater than 3 of potential jurors, we now know that that was unconstitutional.
Yeah. Thank you.
Okay, thank you very much.
Thank you. Ms. Greening, have you any observations in reply?
Ms. Greening, if you're speaking, you're mute.
Yes, good afternoon, President and Court of Appeal.
Good afternoon.
I have a few points to make in reply. I should think I'll be about 15 minutes.
Fine.
President, I'm particularly interested in your question of this morning to the respondent about the correct test that this court, the Court of Appeal of Bermuda, must apply and consider.
Yes.
Yes, His Lordship quoted from 3 different cases, and I made a note. Bestel, which I think was reiterated in Ruddock and Joggi, the test of substantial injustice. Then there was Anor, the Irish case.
The Irish case, yes.
Fundamental unfairness amounting to a denial of justice. And
Yes.
then there was Grant, the Jamaican case, so substantial as to far outweigh the public interests in the finality of litigation. His Lordship this morning asked one which the Crown embraced. And the Crown said, irrespective of the test, these cases do not meet it. Respectfully, I didn't find that particularly helpful, and I'm going to have a go now at answering that question.
Well, what I think would say, whichever test whichever test you take,
you must apply the principle of finality.
The appellant stand satisfied.
It is respectfully submitted by me that the court is bound by the test laid out in the Supreme Court decision of 2016 in Ruddock and Joggi. The other 2, the Anor, the Irish case in Anor, and the Grant case, the Court of Appeal case from 2018 in Jamaica, are merely persuasive.
Right.
Equally, the Canadian cases referred to by the Crown, of which there were many, or at least they were included, are persuasive only. The respondent in his reply mentioned the Cadder case, which is a Scottish case that went to the Supreme Court in 2010. And in that case, it stopped retroactive appeals actually in the body of the judgment. It can be distinguished in three ways, and I think it's necessary to address that in reply. Although that was a case that was heard in the Supreme Court, first of all, it predates Ruddock and Joggie, and in any event, it applies Scottish law and therefore the English test of substantial injustice that says you can reopen late appeals if you can demonstrate substantial injustice, which also applies in Bermuda, was not considered in Cadder. Cadder also suggests in the body of the judgment that cases can go to the Scottish Criminal Case Review Commission for recourse. There is no, of course, we know that there is no review commission available to review cases of intendant appellants in Bermuda. And that, in my respectful submission, needs to be taken into consideration by this court in deciding what the appropriate thing to do is here. Unlike Scotland and England, Bermuda has a constitution. And that's the third point that I'd like to make in why Cadder can be distinguished from these cases here. The Constitution protects our citizens' fundamental rights and freedoms, and all statute and common law must be read down in accordance with the Constitution if it can be shown that it's not compatible with the rights laid out in Schedule 1. So going back to the English case of Ruddock and Joggie, I'll just call it Ruddock. It doesn't go as far as to stop retroactive appeals as Cadder does. It allows for appeals out of time if substantial injustice can be demonstrated. The relevant paragraph is paragraph 100, which is a very well-known paragraph in the Ruddock case. It's already been read out at least once in the course of these proceedings, so I won't read it out again unless the court would like me to here, but it's very clear that the test is one of substantial injustice. The case of Ruddock, it might be worth just very briefly looking at because we now need to look at what substantial injustice actually means, because it's an abstract concept that needs to be thought about and considered carefully. The Ruddock case was two appeals joined into one English one and one Jamaican one, consolidated, looking at a misdirection in law that equated foresight to intention in joint enterprise murder cases, and both of them were convicted. It involved a review of the common law principles of the parasitic accessory liability, which had been established in a case from 1985, but had continually been criticized for being unclear and, more importantly, for being unfair. Due to the unfairness, the Supreme Court in the Ruddock case felt duty-bound to clarify the law, and in doing so, they overturned the convictions of those two appellants. They held in that case that substantial injustice had been demonstrated sufficiently to overturn the convictions. The test was further clarified in the case of Johnson the following year, which I included in my bundle of authorities. And that case is quite interesting, I think, because we've got at paragraphs 7 and 8 of that case, it goes on to further define, develop, and clarify.
Where's Johnson to be found? Could you remind, please?
Yes, my lord. In the joint authorities bundle, paragraph 7 starts at page 57.
Yes, thank you.
Appeals against conviction brought in time must be judged in accordance with the well-established statutory requirement identified in Section 2(1) of the Criminal Appeal Act 68. It is not sufficient only for there to have been some misdirection or error in the conduct of the trial. What is critical is that the verdict is thereby rendered unsafe. Indeed, Section 2.2 emphasizes that position by underlying that the court shall allow the appeal if they think that the conviction is unsafe, but shall dismiss such an appeal in any other case. Thus, the decision in any case must be fact-sensitive, which is a submission that's been made consistently by the appellants in this case. A misdirection of law, which was not in reality in relation to a true or real issue in the trial, does not thereby, and certainly not necessarily, render a conviction unsafe. That much was made clear in the series of appeals that followed R versus Preddy 1996, Appeals Court 115, which also modified previously understood common law. In R versus Graham and other 1997 one criminal appeal R302, Lord Bingham, Chief Justice, put the matter in this way. If the court is satisfied, despite any misdirection of law or any irregularity in the conduct of the trial or any fresh evidence that the conviction is safe, the court will dismiss the appeal. But if, for whatever reason, the court concludes that the appellant was wrongly convicted of the offense charged, or is left in doubt whether the appellant was rightly convicted of that offense or not, then it must of necessity consider the conviction unsafe. And I just stopped there to emphasize, for whatever reason, which in my submission means that the court has a wide discretion. Paragraph 8, that a successful appeal will not necessarily follow from a conviction based on the pre-Joggi law was also emphasized by the Supreme Court, which made it clear that the approach applied to convictions, however recently determined. Thus in Joggi, Lord Hughes and Lord Tilson at 100, and that's again paragraph 100, said, the effect of putting the law right is not to render invalid all convictions which were arrived at over many years by faithfully applying the law as laid down in Chang Wing Su. That's the case that confused the accessory, the test for an accessory, and in Powell and English. The error identified of equating foresight with intent to assist rather than treating the first as evidence of the second is important as a matter of legal principle, but it does not follow that it will have been important on the facts to the outcome of the trial or to the safety of the conviction. Basically, what that's saying is that each case needs to be looked at on its own circumstances and facts. And then I also
sorry, what are we getting from this?
We're trying to get, my lord, a clearer idea of what this test of substantial injustice means, and what needs to be applied. And what I'm saying needs to be applied is that the court has quite a wide discretion when it comes to looking at whether substantial injustice has been demonstrated. And the test the test of substantial injustice is just further clarified in the case of Johnson. What we're saying, of course.
Well, just the paragraphs that I don't quite see how in the paragraphs 7 to 8, that has clarified the test of substantial injustice.
In my submission, it's making it clear that, first of all, in contrast to what the respondent is saying, the principle of finality definitely has its exceptions. And if substantial injustice can be established or demonstrated by the appellant, and if the court thinks that the conviction is going to be unsafe as a result, then they can allow the appeal and overturn the conviction. In this case, Section 519 had to have been exercised judicially by the Crown. Otherwise, in my submission, it becomes perverse. A strong inference can be drawn from the standing by of 33 potential jurors that the Crown is attempting to achieve a tactical advantage. And that creates an appearance of bias, if not bias itself, and results in constitutional unfairness. And as a result of those particular facts and those submissions, we rely on the case of Miller and Dixon, which is also a Privy Council case of 2000, which finds that bias contaminates the whole trial process and creates what I was calling in my submissions as a de novo unfairness. This case of Miller and Dixon has nothing to do with actual bias, nothing whatsoever. This is a case that comes off the back of the famous case of Stars and Ruxton, which deals with the bias of judges on the basis that they the bias of temporary sheriffs, temporary judges that are not afforded tenure. So there's no suggestion of actual bias here. It's almost an academic point, really. Notwithstanding, it was held in that case. It might be helpful just to. It was
just before we get there. Why that we've got Johnson open?
Yes.
I mean, in fact, what Johnson does is at paragraph 10. It says, second line, in some cases, the court could have an inherent power to limit the retrospective nature of its decisions. See CADA. In that case, the decision generally to allow those being questioned access to legal advice was specifically limited when applying the law of Scotland by the principle of legal certainty, such that it was made clear that cases which had been finally determined without such access having been granted should not be reopened. Yes. And then it goes on to say the Supreme Court in Joji, which is Ruddock, did not consider it appropriate to go that far. It approved the practice of the Court of Appeal in England and Wales, which Lord Bingham described in Hawkins, of eschewing undue technicality and asking whether any substantial injustice had been done. So that's the formulated test.
And that, in my submission, is consistent with the construction of the saving provision in this jurisdiction, where it issues technical appeals but allows cases that can demonstrate substantial injustice. I would go as far as to submit that it's on all, that our saving provision is on all fours with that paragraph 11 in Johnson.
Right. Right.
And so applying that test, you get rid of the technical appeals, but you look at whether there's been any substantial injustice. My argument is that the substantial injustice that can be demonstrated in this case is one of an appearance of bias, of constitutional unfairness, and if not bias itself. And in order to support that argument, I'm relying on the case of Miller and Dixon, where
that's the three judges.
Yeah. And in that case, and I just think it would be helpful to finish off by reading out a couple of the important parts of Miller and Dixon. At paragraph 8. I don't need to read all of paragraph 8, but right before, sort of about 7 lines up from the top of paragraph 8, it says, I consider that there is a real risk that a well-informed observer would think that a temporary sheriff might be influenced by his hopes and fears as to his prospective advancement. So that's basically.
I'm so sorry, paragraph 8.
It's my paragraph 8.
Oh.
What are the opening words of it? Because
let's see. I need to go back and look at the Joint Authorities bundle.
Could you remind the page of the bundle? Is that at 98, beginning at 98?
Thank you.
That's where it begins in the bundle.
Yes.
Yes, I'll find it.
Paragraph 8, page 100.
Yes, but Miss Greening, when she said paragraph 8, didn't mean paragraph 8 in the case. She meant paragraph 8 in her submissions.
No, I did mean paragraph 8 in the
Did you?
case. Yes.
Okay, where do we?
But if
it's
you,
a different paragraph 8.
paragraph,
Eight is
there's
one-
paragraph 8, which starts on page 100. If you go down to page 102,
Oh, I see.
Right.
Yes.
I consider that there is a real risk.
yes, and then sort of about 10 lines down on page 102, it says,
Oh, yes. Right.
I consider that there is a real risk that a well-informed observer would think that a temporary sheriff might be influenced by his hopes and fears as to his prospective advancement. I just quote that because it summarizes what this case is about. And now I want to go down to paragraph 83, all the way down at the bottom. On page 139.
Yes.
Yes.
But even if, well, the second where it starts, so one has the situation of the appellants having been tried, convicted, and sentenced by a tribunal which was not independent. In the absence of any defense of waiver, it seems to me far from fair to them that they should not have the benefit of a decision which plainly would have been applicable to their cases. The appearance that justice is being done is as important as the actual doing of justice. The independence of the judiciary is not an empty principle which can be forgotten simply because one thinks that a correct conclusion has been reached. Rightly or wrongly, there is always room for an uneasy fear that there might have been some improper influence affecting the mind of the judge, or in this case, jury, who watched this process take place, where he lacks independence. The principle is far too important to allow it to be passed over in the way which the respondent suggested. And then paragraph 85.
Is this Lord Hope? Or...
Lord Clyde.
Lord Clyde, yeah.
Lord Clyde, okay.
85. It should not need to be said that these cases cast no reflection at all on the character or conduct of the temporary sheriffs engaged on them, nor indeed on any other of the temporary sheriffs. And I just pause there to say, it equally, there's no personal criticism necessarily of the Crown. It's just the appearance of bias doesn't need to make those aspersions. Their personal integrity and independence of mind are not in doubt, and it is not suggested that there was any conscious or unconscious bias or any subjective partiality felt or displayed in their work. But it is as important that the appearance of justice be safeguarded as well as the actual doing of justice. And it is on that account that I am driven to the conclusion that the convictions in these 4 cases cannot be held to be fair. Now, it has been held that temporary sheriffs lack independence, a decision which has not been questioned in these appeals, and in the absence of an effective plea of waiver, I see no alternative to a finding that the acts of the prosecutors in each of these 4 cases were unlawful for the same reasons as those which applied in Stars and Ruxton. The principle of independence and impartiality of the tribunal, particularly in criminal cases, is too precious to be put at any risk. I should be sorry if in a case like the present, we were allowed any derogation from that principle, even if the consequences of holding to it involve the invalidation of convictions which from every other angle were safe and unimpeachable. And I don't think I need any to give any.
Do we know what happened after this decision? Because it looks in end of paragraph 85, that every decision of a temporary sheriff was impugnable.
Yes, and as far as I know, As far as I know, they were. I know that this case caused enormous ripples in the Scottish legal community,
Yeah.
of which I was a member at the time. In contrast to the Cadder case, this is a case which made an extremely impactful result on other cases where temporary sheriffs were presiding. But I don't think I need to explain too much why I have chosen to quote those passages, because they are in my submission on all fours with what we're trying to argue here, which is that there is a real risk from what has happened, that the appearance of bias has led to constitutional unfairness. Oh, has somebody gone?
President.
Looks like the president has disappeared.
Bell with us. I think Justice Bell is off as well.
No, Justice Bell is there.
Ah, sorry.
I'm here, but I don't see the president.
No. I think he's back now. We lost your image for a moment, President. You are muted.
No, we can't hear him.
You're still muted. Your mic is muted, President. We
Can
can't
you hear me now?
Yes.
Yes. Ms. Greening, I'm so sorry that everybody froze, and I don't quite know how long you continued talking after the freezing.
I think I noticed pretty quickly that it had frozen. I didn't
But
say.
sorry, can you just help me? Firstly, after this case in Scotland, were a whole lot of convictions set aside because they were made in front of temporary sheriffs?
I'm afraid I don't know the answer to that, but I can certainly find out. I know that it caused ripples and there was a lot of discussion and committee meeting and all the rest of it, but I'm not sure what happened.
Well, it would cause, if on the lines of 85, not merely ripples, but explosions. And why were, I'm not a Scots lawyer, why were temporary sheriffs not independent?
Because they weren't afforded the same tenure that that permanent sheriffs, aka magistrates, are afforded.
Right.
And so it was deemed incompatible with the defendants or accused persons' right to a fair trial to be tried by someone who might be influenced by, same as the magistrates in Bermuda, the acting magistrates in Bermuda that have different contractual rights than the permanent ones that sit here.
So how does the perception arise that a particular temporary sheriff would give an appearance of bias in relation to the decision he reached in the particular case?
It says that because they don't have the security of tenure, they can't be considered independent and impartial.
Where's that?
Well, it kind of goes all the way through but if you look at if paragraph 6 starts with the background of the High Court's decision in Stars and Ruxton. Which is a case of 2000, which before the High Court and again before the Board of Solicitor General accepted the correctness of the decision in Stars and accordingly accepted on the basis of that decision that the temporary sheriffs were not at the material time an independent and impartial tribunal. It follows that the correctness of that decision is not open to review before the board. It's nonetheless necessary to summarize its effect. And then it talks about the effect that that has had and the changes in the law. The accused Stars and Charmers appeared before a temporary sheriff on summary complaint when their trial began, what was not concluded. The trial was adjourned And on that date was further adjourned, leave was given to the accused to raise a devolution issue, which is devolution issue is a ECHR matter raised.
Well, I think I've seen what it amounts to. If you
yes.
look at paragraph 8,
Yes, and then
line 5, the Lord Justice Clerk drew attention to the fact that temporary sheriffs were appointed for 1 year only
yeah,
and were subject to recall at the instance of the Lord Advocate, perhaps without the possibility of challenge. And then there's the passage that you referred us to at page 102, just before subparagraph 4, a real risk that a well-informed observer would think that temporary sheriff might be influenced by the hopes and fears as to his prospective advancement.
yes,
So the apprehension is that because he's only got a year,
and not
he'll try and reach decisions satisfactory to the establishment in order to get another year, putting it bluntly. Yeah.
That's what this case is about. And it was held, and that's why I was at pains to point out that this has absolutely nothing to do with any suggestion of actual bias. It's it's purely focusing on the defendant in the dock and their rights.
Yes. Right.
And so that's that case.
Thank you.
Of course, the other decision that I heavily rely on, as do my learned friends, is the Supreme Court decision in this jurisdiction by the Chief Justice of Trott, which is also persuasive. What I take from the Trott case more than anything else that is most relevant to this appeal is that the appearance of bias that results from abusing the standby provision amounts to a breach of the appellant's right to a fair trial. And that is what, in my respectful submission, amounts to substantial injustice, or demonstrates substantial injustice and amounts to a miscarriage of justice. So that is my attempt to do two things: reply to my learned friend, Mr. Mahoney, but also provide the court with what I see as a roadmap to as to what test to apply, what the facts in a nutshell are in my case, and what case law I'm relying on, which this court is bound by, to support my argument at this appeal.
Well, what it boils down to is that the test, the exclusion from finality, is if there is substantial injustice.
Yes.
And you say that that is binding on us because it's a decision of the Privy Council in Ruddick.
Supreme Court, yes.
Supreme Court, I'm so sorry. And when the question is whether there was a substantial injustice,
yes,
the Chief Justice's decision of itself shows that the appearance of bias means there's an unfair trial, and if there's an unfair trial, there's a substantial injustice.
Yes, and what's helpful in the Chief Justice's decision is his breakdown or his analysis of the law of the appearance of bias and how that ties into the Constitution.
Yes.
Yes, I find that very helpful. And then just to finish off his lordship's reiteration of my submissions, also that the Miller and Dixon case is binding on this honorable court as well. Those are my submissions in reply, unless there's anything else I can do to assist this court.
Could I just, I was just going to say, Ruddock itself, I mean, there were the two cases dealt with together, weren't they? Jogee and Ruddock, Jogee in the Supreme Court and Ruddock in the Privy Council.
Yes.
Yes, because the Jogee case was, yes, one of them was from Jamaica and the other one was from England. So the Jamaican one will have gone to the Privy Council the English one will have been heard in the Supreme Court, but, you know, as we know,
So either way, it's binding upon us.
much of a muchness because they're all the same people up there.
Yes.
And as you say, either way, it's binding.
Yes.
My Lord, with your permission, may I just make point out one observation in the Milner case, please?
Okay.
If one goes to page 120,
Is this of the authorities bundle?
yes, the authorities bundle.
Yes.
The same case that my learned friend was just
Yes.
dealing with, and the decision of Lord Hope.
Mm.
And if one look at paragraph 42, in a nutshell, what had happened, 42 to 43, in a nutshell, what had happened is that the problem came about when the particular act came in force on the 20th of May, 1999, which affected the status of temporary magistrates or sheriffs. And if you look at the authority, actually it only applied and affected, this decision only affected the cases that were dealt with on the 20th of May onwards. It did not affect the cases decided by temporary sheriffs prior to the 20th. So I just want to make that observation that it is not a whole scale application to all cases before temporary sheriffs. The relevant point, the relevant time period was from the 20th of May, 1999, when the relevant act came into force. And that's where the problem started. So it all comes back to the question of retrospective application of decisions. It doesn't apply. It applies from when there is a change in law onward.
Well, what did the Section 57.2 of the Scotland Act do on the 20th of May, 1999?
My understanding of it is apparently that's when it adjusted the status of the temporary sheriffs. Paragraph 43, it was not until the coming into force of Section 57.2 of the Scotland Act 1998 on the 20th of May 1999 that an opportunity arose for a challenge to be made to the system in the courts. It was not long in coming. On the 30th of July 1999, temporary Sheriff Crowe resumed consideration of a case which had come before him for trial on summary complaint in the Lake Grove Sheriff Court on the 5th of May 1999 and had been continued to a date after the 20th of May 1999 for the completion of the evidence. Minutes had been lodged under the Rule 40.5 of the Act of Journal Criminal Procedure Rules 1996, raising a devolution issue as to whether by continuing with their prosecution before a temporary sheriff, the Lord Advocate had acted in a way which was incompatible with the accused convention right to a fair trial by an independent and impartial tribunal.
Yes.
Temporary Sheriff Crowe rejected his challenge to his presiding at the trial, but on the 11th of November 1999, I would just ask the court to look at, it starts from paragraph 12 actually, with the decision of the earlier judge, where that observation was made as to the 20th of May seems to be a line that there's a distinction between cases before the 20th of May and cases that came on and after the 20th of May.
It's because
Were the relevant cases those summarized at paragraph 45, page 122. And the dates attributed to them all seem to have occurred after the Act came into force on the 20th of May, 1999.
Yes, sir.
The Act came into force because that's when Scotland was devolved from England, and the Scotland Act came into force, which said that legislation could not be made that was incompatible with any of the convention rights of the EU. But that was no different from before. It was just that the Scotland Act was, that still applied before, just in a different capacity when England was joined with, when Scotland was joined with England. The Scotland Act came into force, which devolved powers and brought Section 57.2 into force.
But what did 57.2 do?
I'm sorry?
What did 57.2 do?
It meant that the Scottish government had no power. The Scottish government that was created by that act had no power to make subordinate legislation that was incompatible with any of the convention rights of EU law. But my point is that that was no different really from, it was no different in reality than before. It was just that the Scotland Act was creating the Scottish government that wasn't in existence before.
So the Scotland Act meant that the Scottish government had no power to make subordinate
Any
legislation
incompatible with any of the convention rights. And so so after that point on, whenever we as lawyers wanted to make what we call constitutional applications for our clients in court, we would have to make what we call devolution minutes pursuant to the Scotland Act to say that something had come into force or was happening that was incompatible with our client's convention rights, which is what happened in this case. But it has nothing to do with the principles that were which were the same as they were before when Scotland was part of England, or more part of England.
Yes, so it says in 43, Scotland Act came into force on the 20th of May 1999. On the 30th of July, the sheriff resumed consideration of a case which had started on the 5th. Then minutes had been lodged under the relevant rules, raising a devolution issue as to whether by continuing with their prosecution before a temporary sheriff, the Lord Advocate had acted in a way which is incompatible with the accused convention right to a fair trial.
The extent of my learned friend's point is that there just aren't as many cases that would be affected by Miller and Dixon as he's suggesting might be affected by any decision made in this case.
Yes.
That's the extent of the point. There's nothing other than that. It's not on principle or to say that it's not applicable in any other way. It's just to make that blunt point.
Well, what appears to have happened is that when the time came when you could challenge the case on the grounds that it was inconsistent with the Human Rights Act,
yes,
which was on the 20th of May, the challenge was upheld on the 11th of November. And the use of temporary sheriffs was instantly terminated. See the bottom of paragraph 43.
Yes.
Right. Okay. Thank you.
I think the issue is stated at the bottom of paragraph 45.
They all stand or fall together on the same point, which is whether the continuation of the prosecutions before the temporary sheriff was an act by the prosecutor which was incompatible with the appellant's convention rights. And this case decided that it was, in the sense that it was biased and offended an accused person's right to an impartial and fair trial. And as a result, the relief that they put in place was to stop having temporary sheriffs.
Mm. But I mean, the decision that the use of temporary sheriffs was incompatible with the European Convention on Human Rights was made by the High Court of Justiciary on the 11th of November. So that was when the decision was made, but that appears to have been applied to cases that were concluded before then. See paragraph 45. All the cases there had been concluded before the 11th of November. So this does look as if it was an application of, as it were, an exception from the finality rule. Is that right?
They're retrospective cases.
Yes.
Well,
The decision of the court that it was not in accordance with the Convention on Human Rights was on the 11th of November 1999.
yes.
And the four cases before the House of Lords,
27th of August, 16th of September, 12th of October, and 16th of February, way before.
yes.
Yes.
I mean, that's a point in your favor.
Yes, I know. Yes.
Well,
Yes.
don't be put off by it.
No, I'm not.
No,
I just stand by my point that the only I seek to rely on this case, as you know, heavily. The only point that my learned friend can make is that there might be more cases looking to appeal retroactively than there were in this case. And
I see.
that should not put the Court of Appeal off, because the principle stands and remains the same.
Yeah, I follow. Right. Thank you very much. Now, I think all we've got left is the applications for the admission of new evidence. Which affects Mr. Lynch and Miss Greening. Are you, Ms. Greening, are you in a position to deal with that?
Yes, sorry, my lord. I just realised my daughter was waiting to go to horse riding, and I had left her. I've sorted it out. Yes, the application for fresh evidence.
Yes.
Yes. We have two affidavits that we seek to adduce as fresh evidence in this case. The second affidavit of LeVeck Roberts that was filed in November, and the third affidavit of LeVeck Roberts, which was filed on the 3rd of December.
Yes.
We make that application now on the basis that when, on the 17th of November, when the acting president, Morris Kay, made his ruling to allow leave to appeal in these cases, he made it clear that all issues in relation to the jury selection process would be at large, all legal and factual issues. And I believe that's almost verbatim a quote from his judgment. And on the back of that, we sought to adduce fresh evidence. And I'll just summarize the two. The second affidavit of LeVeck Roberts, which was sworn and signed by my client on the 16th of November, states as follows. Matters which I dispose of within my knowledge and are true to the best of my knowledge and belief. To the extent that information has been provided to me by others, I verily believe such information to be true and accurate to the best of my knowledge. I am a prisoner at Westgate Correctional Facility, having been convicted on the 6th of April 2015 of 2 counts of premeditated murder, 2 counts of using a firearm to commit an indictable offense, and 1 count of taking a vehicle without lawful authority. I was sentenced to life imprisonment for the premeditated murders, with 25 years to be served before consideration for parole, with concurrent sentence of 10 years imprisonment for the firearms offenses. I make this affidavit in furtherance to my first affidavit, which was filed in support of the application for leave, my lords, and in support of my application for enlargement of time, which was granted. That paragraph 4, that throughout the jury selection process, the prosecutor was communicating with the police officers in the back of the courtroom who were indicating to him with a nod of the head or otherwise whether to stand potential jurors by or not. Further, it was abundantly clear that the prosecutor was shaping the jury to minimize the chances of a jury of my peers. By this, I mean that many of the jurors who were stood by the prosecutor were young and black. That the current director of public prosecutions, Mr. Larry Mussenden, who's now a judge, was the attorney for my co-defendant, Christoph Dürr. That the prosecutor defending this appeal was the prosecutor at my trial, that at my trial, it was abundantly clear to me that the prosecution were manipulating the jury selection process to secure an unfair advantage to my detriment through racial profiling and other unknown methods. That I humbly pray my application for leave to appeal out of time is granted. So that was...
Yes. Just pausing there for a moment. This is in effect, as I understand it, an allegation of actual bias, in the sense that, or actual misuse, as opposed to an appearance of misuse by the prosecution. What's being said is that they were attempting to pack the jury.
These are my client's observations.
Well, I know they're your client's observations, but all this evidence in this second affidavit, and indeed the third affidavit, was available at the time of trial.
Well, in the course of our submissions over the last 2 days, we have, I think, made it clear that there is a perception of bias, an appearance of bias. If we have an appearance of bias and that has been made out, then we don't need to prove actual bias as the law states.
You don't need this affidavit.
And so this affidavit is not necessarily required, but these are the observations made by my client. It's enough to have proven or shown, demonstrated actual bias by the fact that 33 standbys were made irrelevant of what happened after that, or irrelevant to what my client may have thought was going on or not. And equally, the third affidavit of my client says that he did not mention in his second affidavit that these police officers were also prosecution witnesses in the case against me. I can recall that one of them was Nicholas Pedro, but there were other officers present too at the jury selection process who were communicating with the prosecutor who testified for the Crown. I recall at that time feeling this was extremely unfair, and I still feel this way. And that affidavit in my submission is in support of not only actual bias, but also appearance of bias.
What was Pedro's evidence at the trial?
Pedro's affidavit in reply says that, at the trial,
Yes.
he was the senior investigating officer who effectively, well, he ran the investigation. And
did he actually, it says here that he gave evidence.
yes, I understand.
Prosecution witness.
I think you'd have to ask Mr. Mahoney what the extent of his evidence.
He did not give evidence.
He didn't
He
testify.
did not give evidence.
No, he did not.
So the investigating officer is.
But my client's position is that there were police officers present who were assisting the prosecutor in the jury selection process who were witnesses in the case. And surely, if that was happening, then not only would that lend itself to an appearance of bias for sure, but go as far as to suggest actual bias. Because we can't have the prosecutor who has the right of an unlimited standby, thereby going further and using the witnesses in the case who should not even be in the courtroom to assist in manipulating and shaping the jury to their advantage. Surely the only thing they have in their minds at that time is to secure a conviction, which is their job. But that shouldn't have anything to do with who sits on the jury.
But sorry, I come back to where I was before. The case that was being made apart from these affidavits was that there was a realistic apprehension of bias by reason of the misuse by the prosecution of its power of standby, because it stood by in the end more than three. That's what appears in the rest of the case. But these affidavits appear to be an assertion of not an appearance of bias arising from the use of the standby provisions, but an actual attempt improperly to shape the jury. And that it relies upon material which was available to your client because he saw everything that happened at the time of the trial.
Is the concern that he ought then to have raised that as an issue?
Yeah,
Yeah, he was in a position.
because I mean, one of the tests for the admission of new evidence is that the evidence ought to be called was evidence not available at the time of trial. I mean, is that not right?
Yes, I suppose my position at this stage, now that the submissions have unfolded as the way that they have, is that the appearance of bias in this case is so strong that and looking at the difficulties with the fact that this is evidence that was available at trial, and the replies that I have received from the respondent and their affidavits in replies, it may not be necessary to further this argument because of the appearance of bias being so strong. I don't need to prove actual bias, because as we know that the appearance of bias is enough to amount to a miscarriage of justice. I suppose that's the honest position that I find myself in right now.
Right. Well, shall we proceed not to consider this evidence which was available at the trial?
I think that's right. I think my argument, as it stands right now, that the appearance of bias on the numbers, the high number of standbys, and the case law and support and all the rest of it, means that we may not need to use these two affidavits in support of my appeal.
Right. Well, just to make sure
President,
there's
there's evidence filed in response by the Crown, and it would follow that we wouldn't have regard to that either.
No.
Naturally, it would flow that I wouldn't have regard to that if I wasn't pursuing this argument here.
Right.
Bias.
Well, just so that there's no misunderstanding, are you content not to pursue the argument insofar as it relies upon these two statements?
No, it would seem so. Yes.
Right. Okay. Right. Well, we right. I'm not pursuing the application. So you're not pursuing the application for new evidence in these affidavits, and we won't look at the responsive affidavits either.
I'm content with that, President. Yes.
Thank you so much. Right. Well, that leaves, I think,
me.
Yes, it leaves you, Mr. Lynch. Sorry.
Not at all. As I indicated yesterday, you have a comprehensive submission in writing set out in the supplemental submissions at page 52. And I don't propose to simply read those out or to address them in any detail. As I indicated, I want to, I hope, fairly shortly encapsulate, first of all, what it is that we're seeking to rely on, and secondly, the hurdles that we have to surmount in order to do so.
Yes, that would be helpful.
So the first thing is this, is that this is an application, as you'll appreciate, for the admission of fresh evidence in relation to two potential witnesses who might give or would give evidence if permitted to do so in accordance with the affidavits that are set out in pages 142 and 148. The upshot is this. Firstly, that here, perhaps uniquely, we have statements or affidavits from both the person who it is said was the actual killer, and secondly, for the person who is supposed to have been the actual victim. That perhaps is a somewhat unique position to be in that you will appreciate that the case is one where it was the rider of the motorcycle who was the appellant in this case, and the victim was an innocent bystander who was shot. This, and as I have indicated, we accept we have a substantial hurdle to overcome, because this formed, at least in part, submissions made at the first appeal of this appellant. They were rejected by the Court of Appeal. And so in order for us to overcome the hurdle that we have, you would need to be persuaded to reopen this aspect of the appeal in the interests of justice. I don't, again, propose to rehearse our arguments that we set out as to whether or not a Court of Appeal can reopen an appeal, which have set out at paragraphs 16 to 33 of our original submissions in support of both this application and the jury point. In our submission, in the end, the central issue for you to determine is it in the interests of justice to permit this evidence? And in a nutshell, the evidence is this. The Crown's case at trial was that Mr. Rashid Mohammed was the rider of the motorcycle. He had seen the victim that he intended to shoot, Mr. Ryan Ferbert. Mr. Rashid Mohammed went away on his bicycle and came back as the pillion passenger with our client riding the motorcycle, the appellant riding the motorcycle. So it was on the second occasion that the appellant was seen to be on the motorcycle as the rider. Mr. Rashid Mohammed got off the bicycle and shot the victim, got back on the bicycle and was driven off by the appellant. The evidence that we seek to rely upon now, Mr. Rashid Mohammed says, I was not there, it was not me. And Mr. Ryan Ferbert says that when I saw the bicycle the first time, the person who was riding the bicycle, that is to say, the driver of the motorcycle, was the same person when it came back. That completely undermines the case, the Crown. And the case again was reliant almost entirely on one witness, Troy Harris, who says that he had received a confession from the appellant that he was that Rashid Mohammed was the killer and that he was the rider of the motorcycle. There was, and I would hope that Mr. Mahoney would accept, that whilst there might have been other little snippets of evidence, without Troy Harris, there was no case for the Crown. Certainly that was the approach taken on the last appeal. So our position is simply this, is that if those two affidavits now adduced were to be permitted to be used in front of any fresh jury, they are both believable and cogent and would seriously undermine the evidence of the one witness against the appellant, Mr. Troy Harris. As I say, I don't begin for a moment to minimize the hurdle that we have to overcome, but your lordships will understand that there is no Criminal Cases Review Commission in Bermuda, and so the burden of considering such evidence as this must always lie with the Court of Appeal. These two witnesses have set out in detail, as you will see from the statements that they have made, that they were from start to finish and even still remain fearful of their own security. But notwithstanding that, they have now been, I hope I can put it like this, persuaded of the need for them to give evidence should they be permitted to do so.
Justice of Appeal Kay described Ferbert's affidavit as long on opinion and belief, and in relation to admissible content adds little to as evidence as presented to the jury.
Yes. And the position is that the affidavit now is different from the affidavit then, in that then he omitted, as you'll have seen in his current affidavit, that he omitted to refer to the fact that the second sighting included the same rider of the motorcycle.
Yes.
Which was a substantial change and flies in the face of the Crown's case. So, of course, I don't, as you will have seen from the exchange between his lordship Kay and myself, I couldn't gainsay that suggestion that it was thin on the ground. The fact is that he was a Crown witness to start with. He failed to turn up on day one of the trial or at all. And as I recall it, Mr. Mahoney made clear that the inquiries were made and they couldn't trace him or find him. We, that is Mr. Mahoney and I, managed to agree at least elements of his evidence which could be read before the jury. But it's obvious now, we say, that he was A, scared, and B, had further evidence that he could give. And had he been able to give it, or had he given it, it would have, we submit, have had an important impact on the evidence of Troy Harris. And
the amendment is evidence that wasn't available at the time of trial.
No, I mean, none of us, in fairness to Mr. Mahoney and the Crown, they didn't know where he was either.
No, I mean, sorry, the amendment, in other words, the material in the second affidavit, which
yes,
was not in the material considered by Justice of Appeal Kay.
No.
It's material available.
It was not available then. It was not available.
Why was it not available?
Well, he had made a statement to the Crown, which didn't include any of this material. When we obtained a affidavit from him for the first appeal, yes, he did not include any reference to the second sighting of the motorcycle.
That's my point, Mr. Lynch. He could and no doubt should have.
He could and should have, yes. There's no question about that. He both could and should have. And he explains in the affidavit that it was an omission on his part. And of course, it's something we did not know.
Well, that may be, but that's not exactly the issue, is it?
No, I accept that entirely. I mean, of course, it isn't directly the issue. Indirectly, we're not in a position to have been even able to ask him about that because we simply didn't know.
And in relation to Mohammed, there was also this question of the fact that although it was said that you weren't able to get hold of him, he was in fact seen in the courtroom on the second day or at some early stage.
I think either the first or second day, he was at court. I didn't know what he looked like, but I was told he was at court. We required him as a witness. We wanted to call him as a witness. He was due to be on standby. Obviously, we didn't know exactly which day he would be required. We made it clear to him that we wanted him. He obviously...
But the same point can be made.
Sorry?
So the same point can be made that technically his evidence was evidence that should have been available at trial.
Well, I mean, both of them should have been there to give evidence. There's no question about it. Yes. The question is whether or not, in looking at the overall fairness of the position, is whether or not we were in a position to do anything about it. We were in touch, or we tried through my junior to be in touch with him throughout the trial, sending him messages saying what day he might be needed and so on. We had no...
What, this is Mohammed you're talking about, is it?
Mohammed now, yes.
I thought your junior was in fact communicating with Mohammed's family, or...
Yes, not directly with him, that's right. It's with the family. And we didn't know where he was. And there was little that we could do other than to keep calling him. We had no reason to believe he would not be available.
So wait a moment, you were told that he was at the court. You said, or the note that I made, we made it clear to him that we wanted him. Now, do you mean by that we made it clear to his family that we wanted him?
No, I ought to be clear. We made it clear to our client's family that we would wish to have Mr. Mohammed give evidence. I was
Yes.
told that he was at court. I can't remember if it was day 1 or day 2, but it perhaps doesn't matter very
I think
much.
it was day 2.
Yes, I mean, I was told he
You
was
were-
at court and
and
was
you
going
and-
to be giving evidence.
I'm sorry. I was trying to be helpful, but I'm cutting across you. Yeah, you and Miss Tucker were told subsequently, but nobody realized he was there at the time, did they?
No, because we didn't recognize him. We didn't know what he looked like. We were told later that, in fact, he had been at court.
Yeah.
Yes.
Well, sorry, take this more slowly because it's quite important to get it down right.
Yes.
Mohammed was at court at some stage.
Yes,
You were told that he had been at court.
Yes.
You made it clear to your client's family
Yes.
that you wanted Mohammed as the witness and sent messages to the family of your client saying we wanted him.
Yes. We were told that they were in direct contact with him.
Mm-hmm.
They who?
It was made clear to us he was apprehensive at all stages about his security, but we had no reason to believe that he would not attend.
You were told that who were in direct contact with him, Mr. Lynch?
Our client's family were in
Yes.
direct contact with him.
And I'm looking for it, but have not been able to find it. Ms. Tucker swore an affidavit in relation to her contacts with the family.
She did indeed, yes, and I can make that available. I'm not sure if it's in the bundle. I don't think it is, but I can certainly make it available.
Well, I've seen it.
Yes.
Well, what she says in it, if you look at the judgment of Justice Kay, in the case, it's tab 19 of the record of appeal.
Yes, does your lordship have a page number?
Yes, I do. It's page 228.
It's the start, and then
That's
fresh
the-
evidence 241.
Sorry?
The fresh evidence section starts
Yes,
at
241. But at page 243, what Ms. Tucker said at paragraph 39 included the following. During the trial, I had indirect contact with Mohammed, indicating that we wished him to give evidence and to make himself available. He did not. We were unclear as to whether he was even in the jurisdiction, but we had no evidence that he was either scared, in fear, or otherwise being restrained from giving evidence.
That's right, because at that stage, we knew nothing beyond the fact that he, having indicated he was prepared to come, where he was, once he did not, where he was, or because we had no contact with him at that stage, we didn't know anything about it.
But you said to me a moment ago, it was made clear to us that he was apprehensive. But
Yes.
Ms. Tucker's evidence is the contrary.
Well,
We had no evidence.
I think that's my fault. When I say it's been made clear to us that he was apprehensive, that's not at that time, subsequently.
Right.
I've emailed the members of the court Ms. Tucker's affidavit.
I think most of
Yes.
it's set out
Yeah.
in case judgment.
I think the salient parts of it are in the judgment.
Yes. So what was said, if you go to page 246, having set out a little earlier Mohammed's then affidavit, unsworn. At paragraph 44, Justice Case said this: the first question to arise in relation to all this is whether the evidence, such as it was not available at the time of trial. I say such as it is because an unsworn affidavit from an alleged accomplice does not immediately inspire confidence. The fact is that Mohammed's evidence is not shown to have been unavailable. He had not manifested fear to the appellant's legal team at that time. He was in the court building for part of the trial. We're not told of any attempt to secure his attendance as a witness by legal process, nor of any attempt to obtain a statement or a proof of evidence from him until after the trial, their application for a short adjournment to find him. Whether or not Mr. Lynch would have called him with nothing more than his interview record as a foundation, and in the knowledge that Mohammed would have to be advised by the judge as to his privilege in relation to self-incrimination, is difficult to fathom. I'm not satisfied that the evidence of Mohammed, such as it is evidence that is not available at the time of trial.
Yes. Well, his current affidavit, which is signed, sets out why he says he behaved in that way, and why it is that he was reluctant to sign or to give evidence even later, which is all predicated on his fear of what might happen to him. Now, of course, it can be said, as I no doubt Mr. Mahoney will, as he did on the last occasion, well, if he was at court on that day, why couldn't he come to court on another day? The short answer is, I have no idea what might have happened to him on the day that he did come to court. Whether anything was said or not said to him, I simply don't know. I'm not inviting any speculation at all. What I'm saying is that at the moment, all we have is the affidavit in which he sets out his genuine fear and the reason why he was not prepared to come either at the trial or indeed to sign his affidavit for the first appeal. Turn up where he deals with it in his affidavit.
Yes.
But Mr. Lynch, apart from the explanation or profit for not having come forward, in substance, what Mr. Mohammed would have to say was already indicated in the draft affidavit.
It was indicated in the draft affidavit. The substance of his evidence.
Paragraph 46, Justice Case saying that there are insurmountable problems in the way of admitting the so-called fresh evidence of Mohammed. So in substance, it seems that the court has already expressed a view on whether or not it ought to be admitted.
Well, I don't pretend for a minute that everything in an affidavit is admissible in a criminal court. We never realistically got that far. The position is this, is that the Crown's case was that he was the shooter. He was the killer. He was the person who first saw Fervert on the bike when he was on his bicycle. He turned around, he pointedly looked at him, paused, drove off, went and got, according to the Crown, our client, who then became the rider of the motorcycle, and brought him back so that he could be shot. Didn't find him, didn't find Mr. Fervert, he found someone else. Now, it seems to us it would be perfectly admissible to call someone whom the Crown say was the killer and to say to him, where were you on that day? Did you shoot at Colford? These are, in our submission, perfectly admissible questions that we would have been asked. Now, of course, he'd have been open to cross-examination, and he would have been open to be told, as the judge points out, that he need say nothing at all.
Yes. I mean, the basis on which the evidence was not admitted was that the affidavit was unsworn.
Yes, ultimately that was it.
And the only other material was his denial that he had anything to do with it under caution. The position that we're now in is that he has sworn an affidavit.
Yes.
And are you entitled, having failed first time round, to produce evidence that ought to be admitted because it's wholly unsworn, then a year later to swear it and say, well, can I have leave now?
Entitled, yes. Whether or not it's granted is, of course, lies in your hands. Entitled on the basis that it always must be, in our respectful submission, in the interests of justice as a test. Of course, you're entitled to view what it might be contained in that affidavit with cynicism, if that's the approach that the court is minded to take. We would urge you not to do that and to recognize that there have been far too many gang killings on these islands, and that it is not surprising that there are those who are connected in one way or the other to be scared of their individual positions, and that the likelihood of any of them coming forward to give evidence in a trial is always very, very little. But we have now been able to persuade two people, one who was a Crown witness and one who's a defence witness, to come forward and say that this is the position. As I say, ultimately must depend on there can't be an endless stream of appeals, of course not. But this is perhaps a unique opportunity to identify, on the very basis that Mr. Mahoney did in answer to one of the questions in relation to the jury point, of what might be regarded as exceptional. Let's suppose, just for the moment, that both of what they say in their affidavits is true, capable of belief, and a jury believed it. There is only one witness the Crown had, which is Troy Harris, whose evidence is entirely dependent on what he says took place between him in a conversation between him and the appellant. And the facts of what happened are entirely what the appellant told him happened. He wasn't present. He didn't see any of it. He knows nothing of it other than what he's been told. And part of what he says he was told was that Rashid Mohammed was the killer. If that is the case, and we call Rashid Mohammed, it would be open for the Crown to cross-examine him in whichever way they like. But the jury might believe that he was not the killer. And if he was not, that would seriously undermine the account given.
Yes. Forgive me, right. Where is the Mohammed affidavit? I can't find it.
Page 148.
Of what?
Of the record of appeal.
Yes.
Oh yes, so it is. So, right. Just help me on one thing. If you go to page 152.
Yes.
Well, between pages 150 and 151, Mr. Mohammed sets out his previous affidavit.
Yes.
And
sorry? That is what was before the Court of Appeal on the last occasion.
It is.
Unsigned.
Yes. But what he appears to have done is to add a signature in front of a solicitor in Manchester.
Yes.
Purportedly on the 3rd of February 2019,
yes.
Which can't be right. What I suspect has happened, if you go to page 156, is that affidavit number 2, which this is, was in fact sworn on the 3rd of February 2020, and it was thought appropriate to swear to the previous affidavit in the middle of this affidavit at page 152, because it's the same person before whom the matter is sworn, but they put 3rd February 2019 when it should be 3rd February 2020.
Yeah, I think that the original affidavit was left open with
Quite.
the date and just of 2019 typed in. It
Yes,
was never
right.
signed, so it never happened. And then, of
Right.
course, when the additional paragraphs were added, when he was willing to sign it, we've ended up with a date of 2019 instead of 20.
Yes.
I'm not sure that's fatal.
It's rather confusing when paragraph 8, page 152 says the statement above is in an unsworn state.
Yes.
And
Yes.
in fact, anyway, that's a distraction. Anyway, you say that these two sets of evidence from the alleged shooter and the alleged victim are capable of belief.
Yes.
One of them was intended as a witness for the Crown anyway.
Yes.
And if the jury were to believe them, your client would be entitled to be acquitted.
Yes.
That's what it amounts to.
That is.
Right.
And I do appreciate I'm having a second bite of the cherry.
And Justice of Appeal K, at page 247, when he finished talking about Mohammed, said, "For my part, I'm not satisfied that the evidence of Mohammed, and I repeat, such as it is evidence that was not available at the time of trial." So if that was true for the unsworn statement, it would similarly be true for the sworn affidavit.
It would be. What I would say to that, I mean, I'm always a little reluctant to try and go behind a finding of any judge of Court of Appeal in these circumstances. But in our submission, I think that there is a slight confusion between it being actually available and us being able to make it available. So, I mean, in the sense that the person existed as a witness and that he had an account to give, that is true. That
Right.
we had...
I don't put it any higher than that. I don't think Justice K did.
No. All right. Well, I don't need to take it. Thank you.
So you say the person existed and he had an account to give, but you did not have that account available to you?
Well, all we had was what he'd said in his in an interview that was served as unused material on us, which sufficed for our purposes. I didn't need to take a statement from him beyond that at that time, because that statement simply asserted two primary things. One was he was not the killer, had no reason to be the killer, didn't have any animus towards the victim or the intended victim. And secondly, that he was, at the time, he believed he was at work, and that there may be evidence that might be gained by way of an alibi to support it. That's what he said in his interview with the police.
Working 7 days a week in the tourist industry in February.
Well, you say that with a degree of cynicism, which I entirely
do.
follow. Which I entirely follow. But he did work at a place that was open. And whether he was there sweeping up or actually undertaking tasks with the boats that were coming in, I don't know. I simply can't assist beyond that. But that's what he said. Whether it is... Sorry.
What he told the police was that he was at work.
Yes.
And that was the evidence before the jury.
No.
No, it wasn't, was it?
No. No, none of this was before the jury at all.
So he told the police that he was at work.
Yes.
Did you say that he said something else?
Well, he maintained that it was not him. He was not a killer.
Yes.
He'd done nothing. He hadn't been on the bike that day, hadn't seen my client that day.
Yeah.
He was making his position clear that he couldn't have been the killer.
Yeah. So that was what he told the police, but wasn't in front of the jury.
Nope.
Right. And the position is that his evidence was available, but only in the sense that he was alive and capable of speaking.
Yes.
But it wasn't actually available to your client.
No, and it's not as though we didn't try and make him available. We expect him to be available. I'm sorry, my lord.
It was available, but he hadn't given it to you.
No, quite. I mean, we did what we could to find it. In the end, we couldn't even rely on some sort of warrant or subpoena or anything, because we didn't know where he was. We had no idea where he was. Couldn't serve it on anyone.
Right. Thank you. I'm sorry to have asked quite so many questions.
Not at all.
I see that it's now, I don't know what the time is with you.
4 o'clock.
4 o'clock.
4:08, yeah.
4:08. Mr. Mahoney, where's Mr. Oh, there's Mr. Mahoney. Do you know how long you're likely to be?
Not long.
Okay.
Well, probably if I read my submissions, I'll go quickly. But in a nutshell, there is no material change from what happened before the Court of Appeal on the last occasion in respect of both affidavits. And it's my humble submission that the finding of the court in the judgment, or the finding of this court on respect of those the substantive issues and now should. There's just one additional observation.
Sorry, the finding of the court on the substantive issues should, I didn't hear what you said.
Stand as well
Thank you.
in the case, yes.
Yeah.
I just wanted to point out that in regards to Ryan Ferbert, his situation got a bit worse. And I to paragraph 23 of my submissions. It's our respondents' supplemental submissions.
Yes.
Paragraph 23.
And so paragraph 20, well, I just read from 22, I'll move quicker than that.
Yes, certainly.
The case against the appellant was that he confessed to being the rider who took the shooter to the location and then took the shooter away after the shooting. It was never contended that the appellant was the person who initially rode past Ferbert and then pointed at him when he was sitting on the wall. Also, it was never the case that the appellant was the shooter. Additionally, the evidence was that a black bike was used and the appellant had access to more than one bike, including BR 594, which was also described as black at some point in time. Further, at the time when Ryan Ferbert fled the jurisdiction a few days before the trial, he was aware that the appellant was to be tried for the murder of Colford Ferguson. The respondent further submits that the content of the more recent affidavit of Ryan Ferbert lacks credibility and is a blatant attempt to circumvent this honorable court's findings on the deficiencies of the first affidavit. The second affidavit is nothing more than a fabricated afterthought. For example, paragraph J of the new and reportedly improved 2021 affidavit is ambiguous and would give the impression that the bike returned a second time with just a rider and a third time with a pillion passenger. The agreed evidence has always been that the bike returned once with two persons on it. At the end of the said paragraph, it is stated, and I quote, "I can say that the rider of the vehicle on the return trip had been the same rider which I observed on the first occasion, this time returning with a dark-skinned pillion passenger." This is to be contrasted with what he said in his second interview to the police. And that second view is found at page 175 of the consolidated, 175 of the supplemental bundle of authorities. specifically at starting at page 186.
Just a minute.
Line 32. Where he was asked, and police said, and later when you were talking to Colford on the telephone, on the cell phone, you said that there were two guys on the bike. And from what you're saying, I take it you had a view of that from up here. Your response was, I was right here. Yeah, and at the house. So what did you see of the two guys on the bike? What did I say? What did you see of them? Just looking. They were looking all around the area, like, and then they went. Right, you obviously know your bikes. You obviously know a lot about motorbikes. Yeah. Do you think that was the same bike that was there the first time? No audible response. You do? And do you think one of the people on the bike, when they came back the second time, was the same person that was there the first time? Is that fair? Possibility. No, I'm asking from what you saw and what you heard. Can't really see nobody when they are on a bike that far, like their color and all of that, with the visor and all of that. Now, it's interesting that many years after, two affidavits after, suddenly his ability to see improve with time. And in regards to Rashid Mohammed, we adopt the submissions we did on the last occasion, and we adopt the finding of the court on the last occasion as well. And it is our submission that both affidavits should not be admitted as fresh evidence. As they do not meet the test.
Well, wait a moment. In relation to Mohammed.
Yes, sir.
In what respects do you say that it doesn't meet the test?
Well, first instance is that he was seen in the court building during the trial and was available to give his evidence. The appellant's counsel conceded this fact at the directions hearing before this honorable court on the 14th of March, 2019, at time 10:42:25 a.m. He claimed to be in fear, yet he had no problem as an MOB man attending court, which is located in the area of MOB's arch rival, Parkside Gang. Also, Rashid Mohammed never provided an alibi to the police, as mentioned in paragraph 17 of his police interview. These are all grounds which I had put before the court before, and which the court accepted. On the 18th of April, 2018, he stated he could not recall where he was around the time of the incident. When the matter came before this honorable court, on the last occasion, Rashid Mohammed refused to swear the affidavit, and he did not swear to the content of the affidavit presented on the first appeal. Yet, much of that affidavit is incorporated in the post-appeal affidavit.
Well, wait a minute. Taking it in stages, you say that the evidence of Mohammed was not available at trial, but how do you say that it was available?
I did say it was not available. I said it's not fresh because he was available. I thought that's what I read. Mohammed.
Yes. Well, wait a minute. I mean, what is the position?
Yes, sir.
There's a person who lives in Bermuda, or you think, well, there's a person who may live in Bermuda, but you don't know where he is. And he in that sense, he's available and he's alive and sentient. But but you can't make contact with him. Or when you attempt to contact him through his family, you get no response. Is such a witness available?
In the context of Bermuda, sir, yes, Bermuda is small. Bermuda is not like Arizona or England where there are many miles between persons. And he resides in the area of where the defendant came from. That's up in the Somerset area. The interview that he gave to the police was recorded after he arrived back into the jurisdiction. Ms. Tucker indicated that she was in contact with him throughout the trial. I think that's what was said. Or in
contact with the family?
Yes.
Not with Mohammed personally.
She had indirect contact with Mohammed, indicating that we wish to have him to give evidence and to make himself available. As I indicated, he was actually seen in the trial on the second day. The defendant's mother was at the trial every day. And therefore, it's a bit of a stretch to say that there was a problem in alerting him to the fact that he was required to give evidence. Defense counsel did not even give his name when we were at the start in empaneling the jury and we were calling out the prospective witnesses as well as other names they may hear. His name was never provided by the defense as a possible witness. So in addition to, unless the court wants me to go back over all the submissions I made before this court when the last appeal was heard, well, I could do that if you so wish.
Well,
I was just going to say, Mr. Mahoney, that Justice of Appeal K, towards the end of his judgment, surely says all that you need for your purposes. So at the top of page 247, there's a double negative there, but for my part, I am not satisfied that the evidence of Mohammed, such as it is evidence that was not available at the time of the trial. So then he carries on, also some doubt whether it's capable of belief. Not only is Mohammed unwilling to attend to give evidence, contrary to the assertion in his carefully proposed unsworn affidavit, he's not willing, this is obviously at that time, to swear the affidavit before an English solicitor. That means that the only account which can be formally attributed to him is the one in his police interview. When asked where he was at the time of the murder, his first words were, "I can't recall." So.
Thank you, Lord Bell. I agree with all of that because those are decisions. Otherwise, what would happen is we would be having these repetition after the court make a ruling on a affidavit or fresh evidence application. All they have to do is go and revamp and come back again. And back to the finality point, we'll never have finality in these matters.
I'm sorry to keep coming back to this, but if the position is that there is a witness whom you can contact and say you want him to come, but he declines to come, is his evidence available?
It begs a question, sir, whether or not that is so, because as soon as within a week after conviction, the grounds of appeal were filed. David was ready. affidavit or the suggestion that he was available on the application, they were intended to make an application to provide, to make for fresh evidence, was, I think, included in the grounds of appeal within a week after the conviction. So it begs the question whether or not he was so out of reach throughout the course of the trial. I don't have the grounds of appeal readily before me now, or the notice of appeal, but it is quite clear within a week of the conviction, based on the intended grounds of appeal, there was clear communication with Mohammed.
I'm sorry, I'm afraid it's been a very long day and I would like to break off now, if I may, and I would like to come back to this when we meet next week. In relation to going through the nitty-gritty, how long do we think that's going to take, given that we're only dealing with 2 cases now?
The nitty-gritty, the process in regards to those 2 are much shorter than Roberts.
So have you any idea how long it would take?
It depends on how contentious it may get, sir, especially with Kyrie Smith-Williams. With Brandman, the transcript was short. That should be probably 15 minutes.
Oh, I see.
Half an hour at maximum. Kyrie Smith-Williams was a little longer than Brandman, but not as long as LeVeck Roberts.
Well, it looks tolerably plain that we're going to be able to deal the nitty-gritty and to come back to the question of fresh evidence within a single day.
I would agree with that, my lord. Can I say that I think so far as we've got on what you've described as the nitty-gritty, that Mr. Mahoney and I are in agreement that there were 6 at least of the standbys. I think where the disagreement lies is in 3 or 4 additional persons, which we will do our level best to put a short little document together so that both Mr. Mahoney and the court can have in advance, showing why we say those additional 3 or 4 are of a particular character, and no doubt Mr. Mahoney will be able to respond to that. I don't ask him to produce any such document until he's ready on his feet to do so before your lordships, whenever you decide next week. But for my part, I'm currently due to be in a trial on Monday and Tuesday of next week, representing a bishop charged with some unpleasantness, and I would like to be able to deal with that if I can. So if it doesn't make any difference to the Court of Appeal as to which day, then I would ask for either Wednesday or Thursday. If it does make a difference, then of course I always bow to the Court of Appeal, and I will have to rearrange the other matter.
Okay, we'll consider the question.
Thank you very much.
Thank you. Well, we'll adjourn now.